Going to open court.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Um, Counsel, you'll help me with your last name. I want to get it right. Yeah.
It's Joel, Your Honor.
Mr. Ferguson.
Well, I'm not very sensitive. You know, my children are in their 40s and don't know how to pronounce it, so I answered it.
Well, thanks for your help and welcome, and you may proceed.
Thank you, Your Honor. Well, as I said, my name is Sam Ferguel. May it please the court. I represent Brandy Calhoun, who is the plaintiff and appellant in this matter. It's a disability case, of course. Ms. Calhoun is 30 years old. She was 23 when she applied for supplemental security income in 2019, 26 years old and still living with her parents when she had her hearing in 2022. She's never lived alone. She graduated from high school, but she received special education services in the form of extra time on tests. She was tested in separate rooms, and she had to have the tests read to her. Her father reported that she had particular problems with math and reading. She tried to attend a cosmetology program, but she dropped out because she suffered panic attacks just having to go in. She's never worked. The record shows also that she did not have health insurance during the pendency of her claim. I'm going to try to address three issues today in the case. First is what I guess is an implicit finding by the administrative law judge that Ms. Calhoun could actually attend work despite agoraphobia. And that's related to the judge's rejection of the consulting psychological evaluation by Dr. Broman Folks. The second, I wanted to talk about the inadequacy of the ALJ's determination that she could essentially be on her feet all day, given her obesity and her leg problems. And then last, I've briefed it and I want to address the treatment by the ALJ that she was a high school graduate. Ms. Calhoun was diagnosed with agoraphobia about a year before she applied for disability by her primary care physician, Dr. Baker. The consulting evaluator, Dr. Broman Folks, also diagnosed agoraphobia. She testified that she was never comfortable leaving home at all, but if she did leave home, she always had to have somebody with her. And that actually, there's some proof of that in the record because at virtually every primary care visit, it's not always reported, but most of the time it's reported that she had either her mother or father with her. She testified, in fact, that she couldn't even go to the examining rooms without one of them being with her. The ALJ herself found that agoraphobia was a severe condition, but she rejected the consulting psychologist's evaluation. He had said that she would not be able to perform activities that required her to leave home on a regular basis. The commissioner has conceded, although the ALJ never actually addressed this directly in her decision, that Ms. Calhoun could regularly attend work. So Dr. Broman Folks had several observations, not just that. He also gave the opinion that she appeared to be of relatively low intellectual functioning, that she had very limited coping strategies, and he said that she was severely impaired when it came to her abilities to relate to others and to withstand the stress and pressures of day-to-day work activity.
Counsel, can I just ask you, I just want to make sure I'm tracking where we are in the argument. So, Dr. Broman Folks does say because of the agoraphobia, she can't regularly leave home, at least not on her own. And the ALJ discredited that, I think on three grounds, thought that it was inconsistent with her primary care records, which didn't indicate kind of a severe mental concern. It was inconsistent with the fact that she had not sought mental health treatment for agoraphobia, and it was inconsistent with her hobbies. do you want to kind of address where do you think the ALJ went wrong in that analysis, I guess would be my question.
To a certain extent, Your Honor, all three of those bases. I mean, she really said one thing. The ALJ said, well, it's inconsistent. And those were the things you recited were indeed the examples that she gave. First of all, I mean, almost all the primary care visits were for acute physical problems. So it's not surprising that that would not be the focus of those visits. The ALJ continually, I mean, what she talked about the normal mental status examinations, but a number of those, as I tried to detail in my brief, were inconsistent. So they had a template that said, oh, normal, 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 but there were times that there were observations made that correspond with the agoraphobia, and the ALJ didn't mention these. For example, in one of the visits, it recited that when Ms. Calhoun was questioned, she turned to her mother to answer. She didn't answer directly unless she was kind of asked to answer directly, and then I guess she did. But the mental health, the fact that there are mental status examinations and primary care visits that do not regularly reflect abnormalities, I don't know how that speaks to agoraphobia, but I think the larger point as to Broman folks is he knew that. This was all reported to him. It was also reported to him about her hobbies, which I mean, I'm scratching my head about those, Your Honor, because those hobbies were for the most part pursued in her room, in her parents' house. How that shows that she doesn't suffer from agoraphobia or
what about going to the concert?
Well, that's the big thing that the ALJ recited over and over again. That was a week after. According to the record, that information came from an emergency room record. There was no detail about what that concert was. Was this something?
Can you just help me though? I mean, I understand the sort of argument that you're making on a lot of these points to say, well, maybe you should have believed this part of the record and not that part of the record. Maybe this was not reliable or not, but you know, our standard review doesn't allow us to really do that, does it? I mean, if there's some evidence in the record, maybe it wouldn't be the conclusion I would come to, but if there's some effort in the, evidence in the record that the primary medical records don't support this sort of mental health problem, and there's some evidence in the record that some of her hobbies involved outside engagement in crowds. How are we supposed to reevaluate that?
Well, with due respect, Your Honor, the court. Well, this isn't really a substantial evidence case, I guess. In a sense, every case is. But you've also said, and the court has repeatedly said, there has to be logic to the conclusions the ALJ draws, and they have to be accurate. And there is no logic to saying that a person isn't agoraphobic. When number one, the activities that she cites for the showing that she's not agoraphobic are things that she does in her room. Painting in a room or taking care of her pet duck.
But also the things that are recorded by her primary doctors, like those aren't in her room, right?
There's
the
no
concert's not in her room. I mean, I understand your argument, but I feel like the standard of review, I'm having a little hard time understanding how your distinctions, which I totally understand, help in evaluating, whether the ALJ so drastically departed that we have to vacate it.
Well, thank you, Your Honor. The concert is the one example. I guess that's a big troubling example, but there's no information about that. And first of all, we don't even know what this is. She called it a concert, but we don't know if this was something in the basement of her church. She was sitting, we don't know who was with her, but there's an indication in the emergency room records that probably her mother was with her or somebody was with her in any case. She didn't say she could never leave home. She said she was uncomfortable leaving home. That concert, the single time that she was out and she hurt herself, that doesn't prove anything. She was with somebody. She said that if she left the house, she could do it if she had somebody with her. And the record shows that. Her father was taking her to see the friend that the ALJ cited that she would see on a monthly basis. she always had somebody with her. That is confirmed in the primary care records, and there is nothing. It's a difference between an absence of evidence, I guess, in the primary care records and conflicts. I don't see a single conflict in the primary care records. There's nothing in those records to suggest that she is mentally sound or intellectually sound. At most, they don't record anything. I mean, she goes in because she has digestive problems, and they don't mention her psychiatric care. I don't think that proves anything. I don't think it's substandard that would happen.
Counsel, can I ask you just a question that I guess goes to our standard of review to some extent? So the ALJ gave these 3 examples of inconsistencies. Assume hypothetically I found 1 or 2 of them illogical. Would I then, and let's also assume I thought 1 of them made perfect sense. Then what do I do? Like, if 1 of them makes sense, is that enough? Or do I have to remand because I honestly don't know how the ALJ would have come out had I, pulled out 2 of the 3 underpinnings for this conclusion?
Well, I would obviously prefer the latter, Your Honor.
But do you know what the right answer is? Because honestly, I don't.
Well, I think that if this were a question of discrediting what Ms. Calhoun said, that would be one thing, but that's not what we're dealing with here. What we're dealing with is a very favorable consultative evaluation which showed severe impairment. The information that has been cited and Judge Richardson mentioned, that was all in front. The only thing that was not in front of the consulting psychologist, who's an expert, and I mean, I gave some citations. He's been appearing, he's cited in district court decisions going back 10 or more years. He knew all those things. So, I mean, to me, if the ALJ then takes the same information that the psychologist had in front of him, her hobbies, the fact that she visited her friend, and he still says, hey, she cannot attend regularly if she has to leave home to do it, then that I think you have to remand because it's the consulting psychologist evaluation that got thrown out. If that were accepted, and if the reasons for rejecting that were valid, I think that would be a different thing. But I think that if there was any invalidity in her very skimpy rejection of the consultative evaluation where he had that information, then I think that causes the whole kind of house of cards to collapse.
Can I ask you a question about a different issue? I think it was the second one you were going to address. You have the 2 state experts saying that Ms. Calhoun can stand for 4 hours and do sedentary work. And then the ALJ saying, no, she can stand for 6 hours and do light work. And you argue that there's not enough of a bridge there, not enough of an explanation for rejecting the kind of unanimous view of these 2 experts. Your colleague at least suggests in the brief, even if that's so, it's a harmless error because even if she can only stand for 4 hours, some of the jobs identified by the vocational expert would still be available. And I'm not sure, I actually don't think the ALJ kind of clocked the difference between sedentary and light, but even if, let's assume we're just talking about the hours for a minute, do you have a response to that harmless error analysis?
Well, it's true that the ALJ did float to the vocational expert about the possible reduction. I think that's accurate. So, I mean, I would concede that what the government said is true, that the VE named the one job that could still supposedly be performed with that. But even that doesn't make sense. I mean, the ALJ said that she found persuasive all of the state agency reviewers. There was a total mismatch between the 2 psychological reviewers. I mean, complete mismatch. How she came to that makes no sense. In terms of the physical complaints, I don't know. Well, I don't know how to answer it, Your Honor. I don't have a good answer for it. I mean, frankly, we don't believe that the 4 hours a day is enough of a restriction, because the testimony, I believe, was credible that she had to alternate between sitting and standing on a fairly frequent basis. The ALJ didn't even deal with that at all. So if I think maybe an answer is, if you have to alternate between sitting and standing because you can't stand the whole day to do the light work, then there has to be some interval in which the person changes between sitting and standing. But
Can I ask you a maybe related question? On J 697, which are part of her medical records, the medical records report, at least at this time in 2015, which is not when we're talking about, but she described standing at school for 8 hours a day. What do we do with that? Piece of information, right? We know she was in school through 2017. This suggests that she was standing, I don't know whether it's right or not, but at least the record says it. I don't know what am I supposed to do anything with that, or do I just ignore that? It seems like an odd piece of information given the issue that we're talking about here. I just am curious what your take is.
Well, first of all, the ALJ prevented us from putting on evidence about the pre-application time period. She said, oh, well, that's for historical purposes only, and she interfered with the questioning. She didn't want to hear that evidence. I don't have an answer for the 2015. I have no idea what was going on then. We know that she injured her knee at that concert, the 2019 concert, a week after she applied. But this is somebody who weighed almost 400 pounds. At times, she weighed over 400 pounds on a 5'3" frame. I mean, a BMI of over 70 at times, the high 60s almost all the time in this record. Again, it's a question of logic. Can a person, she testified that she could not be on her feet continuously at the hearing. So, I mean, that's what I have to go on, Your Honor. I don't really have an answer about what was happening in 2015. I really don't know. I don't think the record reflects it. But the ALJ herself said it didn't matter. So, I mean, I think you have to take her at her word. I mean, this is 4 years after any 2015 report. I mean, she also, the ALJ played down. I mean, there's an MRI. I see I'm about to run out of time here, but I mean, there's an MRI, and I can't give you the site off the top of my head. I'm sorry. I have it written down, but I don't know where. There was an MRI that showed many more problems with her knee, just the knee, than what the judge said. And the judge found the knee was a severe impairment, by the way, as was obesity. So, I mean, if it's severe, then it has a significant or causes significant limitations by definition. She minimized that. So, thank you. I'm sorry. I see that I'm out of time, so I apologize. Thank you.
Thank you, counsel. Ms. Domenico.
Good morning. May it please the court. Ms. Calhoun hasn't shown any legal error or that the ALJ's decision is unsupported by substantial evidence. What she's asking this court to do is to reweigh the evidence and interpret it in her favor, and that's just not the court's role on judicial review. What the ALJ did in this case was she followed the law, she weighed the competing evidence, and she issued a decision with sufficient rationale pointing to substantial evidence as to how and why she reached her conclusions. I'll start with the CE, the evaluation of the CE. First, that consultative examiner who only examined Ms. Calhoun once didn't have the benefit of the entire record like the ALJ did. This consultative examiner didn't know that just months before, Ms. Calhoun had attended a concert, even though she said she rarely left her house. He also didn't know that Ms. Calhoun...
Can I just stop you right there? There's actually no inconsistency in those two things you said. She said she rarely leaves her house, and she has extreme discomfort about leaving by herself. And that's not a however. One of the rare occasions was when apparently with someone else she went to a concert. So what's the inconsistency there?
Well, I think that she didn't tell the consultative examiner that
He
fact.
didn't have that fact. Okay.
Right. So that's that. So he didn't know necessarily the full picture. This young woman also applied for bartending positions and stocking positions during the relevant period. So that says something about the extent of her limitations if she's trying to apply for bartending, which is very socially interactive. But beyond that, the ALJ, when she looked at the CE exam, had the benefit of seeing the state agency doctors who had also reviewed this report and found that Ms. Calhoun retained mental functional abilities. The ALJ had the benefit of looking at her primary care records. Now, while Ms. Calhoun tries to discount the value of those records, these are the providers that were prescribing her medications for agoraphobia and anxiety. These were the people that she treated with because she declined talk therapy. She didn't have specialized mental health treatment.
So can I ask you a question? Because I think we should probably stick with sort of the reasons the ALJ gave for discrediting or discounting this report. And two of the reasons are what you just, putting to one side the hobbies. The other two reasons were the ones you just gave. You know, her primary care physicians were documenting mostly normal mental status, and she didn't seek out or additional treatment for agoraphobia. And I would tell you that my concern is I think it's pretty clear. I think agoraphobia is a tricky one, and I think it is pretty clear that an ALJ is supposed to consider whether a claimant is making behavioral modifications that make it unnecessary to get additional treatment and that might allow that person to present with normal mental status. So basically, if an agoraphobic is staying home and not leaving home without someone with her, you would actually expect her to have relatively normal mental status. She's not doing the thing that causes anxiety, and she may that may be why she doesn't feel the need to get additional treatment for the agoraphobia. And I know that, I mean, an ALJ is supposed to consider whether a claimant's own behavioral modifications account for things like normal mental status and failure to get additional treatment. And I just didn't see that happen here. So that's my concern.
Well, Your Honor, if you look at the primary care treatment records, Ms. Calhoun did talk about a situational stressor. So she reported increased symptoms after a friend died of COVID. And she actually talked to her primary care providers about that. And I think that informed the ALJ that when she had increased symptoms, she was willing to talk to her primary care providers about it. But for the most part, she wasn't doing that.
Because she didn't have the increased symptoms because she was staying home. Like, I'm not sure that that is really responsive to the concern I'm raising. And I do think agoraphobia, this is the first agoraphobia SSA case I've seen. It does seem to present very sharply this idea that there are certain mental conditions where you can make behavioral modifications that will bring down, for the most part, the level of mental disturbance and also make it unnecessary to seek treatment, particularly treatment that requires you to leave your home and be with a group of people. That people might make a choice to modify their behavior. And that doesn't end the inquiry, but it is something an ALJ is supposed to consider. I can't remember the name of the, I know there's like a bulletin or something that says ALJs need to consider this. So do I not need to worry that that didn't happen here?
I think that if you look at the entire decision and what the ALJ explained as the basis for her fact finding, that is enough. This is a young woman who declined talk therapy. She did say that she was anxious in a group therapy setting, but this is in the era, the height of COVID. Certainly, she could have tried to seek treatment to work through her agoraphobia, at least through talk therapy from home, through telehealth. And she didn't do that. And claimants claimants have to help themselves a little bit as well. They have to seek the treatment that they need. And the record also showed that she applied for bartending positions, stocking positions. She did go to the YMCA for water aerobics. She did leave the home to go to all these primary care visits. And yes, she was accompanied by a parent, but this is a young woman who never had a driver's license. So, I mean, that's also, I mean, the ALJ did say that, she needed a ride to these appointments. But what the ALJ did here is, and the question before the court always is there the mere scintilla of evidence to support the ALJ's fact finding? And we have that here. The ALJ identified various lines of evidence, the lack of specialized mental health treatment, and she never sought emergency room care. Again, we have those two state agency medical experts, and we do have her activities. And is that enough? And even if this court would disagree, that's not what the issue is. Could a reasonable mind find as the ALJ did here? And our position is yes.
Can I ask you another question about how the ALJ got from these two agency experts who agree that Ms. Calhoun can only do sedentary work and she can only stand for 4 hours, no more than 4 hours a day, to actually she can do light work and she can stand for 6 hours a day. And I know she does talk about the knee pain, but the ALJ just seems to be of the view, she disagrees with the doctors about how serious the knee pain is. And I'm not sure what the basis is for an ALJ kind of just making a different medical diagnosis. But she doesn't mention the other primary basis for the doctor's analysis, which is the neuropathy. And I didn't see the ALJ acknowledging a difference between sedentary and light work. So I'm troubled that we don't have a bridge here that kind of explains how the ALJ got from 4 hours sedentary to 6 hours light. And I want to give you a chance to explain to me where I should find that bridge.
Certainly, Your Honor. Well, at the outset, I don't believe that the state agency's RFC was for sedentary. That was, it's a range of light because of the lifting and carrying requirements. It's 20. And the vocational expert also categorized 4 hours as light. So if you look on page 70 of the transcript, when the ALJ asked the VE about 4 hours standing and walking, the VE confirmed that that's light. So the ALJ really agreed with the state agency, except for the reduced standing and walking. And as you pointed out with my opposing counsel, the VE confirmed that at least 2 jobs existing in 130,000 positions in the national economy could be performed with reduced standing and walking. And the VE goes on even to testify that if you look on page 74, that these are even able to be performed with a sit-stand option at will. So that's even more restrictive, and they could still be performed if she needed to sit or stand about 15 minutes at a time. So that supports this non-disability finding.
All right, so I just want to make sure I understand your argument. So I asked you, where is the bridge?
Okay.
And I'm understanding your answer to be, don't worry about whether there's a bridge, because even if there is no bridge, it doesn't matter. This was a harmless error. So is that the argument you're making?
No, and then I will point out the bridge as well.
Okay.
So on page 25 of the ALJ's decision, the ALJ explains precisely why she does not accept the standing and walking of the state agency. And she cites to the longitudinal records with few abnormalities, fairly minimal treatment, and she didn't report consistent ongoing pain, and actually described her pain as waxing and waning on one occasion. So despite her obesity, these fairly minimal objective findings support a finding of the standing and walking. And that's the precise bridge that the ALJ included in the decision to explain why her RFC differed a little bit from the state agency. But my second argument is that it doesn't matter anyway, because this VE confirmed that the jobs could be performed. No other treating sources suggested that Ms. Calhoun had greater limitations stemming from obesity, knee pain, anything else. So the ALJ, our position, of course, is that she identified that bridge right in the decision for the reviewing court.
Counsel, my question to you is that uh, a person with this constellation of problems, for example, hypertension, pain in her legs, anxiety, panic attacks, knee problems, and you can imagine, as counsel said, he's right about her weight. She's morbidly obese, morbid, and we don't need. I know you know exactly what morbid is. I mean, that's about as severe as you can get. And you can imagine, whether you're a football fan or not, but you can imagine that one of the biggest linemen you can imagine who's normally about 6'6", 6'7", take that weight and put it on a body that's 5'3", with a person who has a knee problem. Matter of fact, a weight so severe that it's undisputed, correct? She needs knee surgery, but she weighs too much to get the surgery that she needs. The surgery that she needs, she talks about numbness when she sits down. Again, I don't want to, you answered the question for Judge Harris, but the bridge, I don't see how this kind of thing would lead to, oh, well, with 6 or 4, she can do it all. And she goes to one concert in 26 years. My goodness, I don't understand that. We don't know what the concert was. As counsel said, maybe it was a concert. When I was going to church, a little small church, we called a concert when 2 or 3 choirs got together at the church. But now I guess the image is what? It's got to be thousands of people there. I mean, how do we leap to that? That's the problem. We look at it. How do you take this constellation of undisputed, severe, morbid situations like this and then say, well, yeah, she can just walk around. Walking is hard for her. It has to be.
Well, Your Honor, it's not borne out in the record. That's the issue here. She was walking unassisted at her primary care visits. She had a normal gait, and her primary care providers were documenting fairly unremarkable musculoskeletal neurological findings. It is the burden of claimants to show that they are so debilitated that they can't perform any kind of work existing in the national economy. And this young woman, who was just 23 when she applied for benefits and has never tried working, doesn't have that much evidence here showing that she's so debilitated. She's saying she is, but she applied for bartending positions and stocking positions. Those are physically demanding jobs. She attended a concert. She went to water aerobics. She wasn't complaining that much of significant symptoms. In fact, the primary care records reflect that most of her appointments were for infected piercings and treatment of keloid scars. This isn't the kind of person who was going to the doctor complaining of inability to walk every time she saw her primary care provider.
Counsel, interesting, not putting yourself personally, but the point is that when you talk about, there are people who have so much pain and they don't, to the point where they don't continue to complain about it. I mean, some serious pains. And so you say, well, you can't be in pain because every day you're not moaning about it. No, in some way you had to find a way to suffer through it. But the physical evidence here, in terms of just her knee alone and that kind of weight, putting that much weight on your knee that, that you need surgery for. You know, doc, she tried to lose some weight. And these jobs you're talking about catch 22. Well, if you didn't apply, you see, she never tried to get a job. But if you do apply, look, she's applying for jobs she knows she could have. She is that, you know, nobody wants to give their life up at 23 years old. It's agoraphobia, those kind of things, like telling somebody who's depressed, cheer up, because they can't cheer up. And it just seems to me that this case here is incredibly troubling. You know that these undisputed situations like this that we are talking about residual functioning that's inconsistent with the whole gamut of what's presented. But I suppose you can always say, like you said, you know, you went to a concert, you're not complaining every day. People going through sometimes serious chemotherapy, very painful, but they don't complain because somehow they find a way mentally to try to get through it. But that doesn't mean that they're not. And you take all of those things to see, not you personally, but the record people who look at those things and have make some judgment about the nuances of human experience and come up with this. It just seems troubling. Go ahead.
Well, I would just say to that, Your Honor, that the ALJ is the fact finder in the case. And under, you know, the ALJ has to weigh the competing evidence. And under our substantial evidence standard, if there is more than a mere scintilla and less than a preponderance, the Supreme Court has said it's a not high standard. And
So
we
as you-
certainly
can I
have
just-
that here.
Can I just, so as you read the ALJ opinion, is the ALJ basically saying, like, I don't believe you. You say you're agoraphobic. I don't believe you. You went to a concert, you applied for jobs. And like you feed your ducks, some other stuff that the ALJ thought was inconsistent with agoraphobia. Is that your understanding? Like, this is a credibility determination by the ALJ that this woman is not agoraphobic, obviously. She left the house to go to a concert.
No, because the ALJ credited agoraphobia as one of her severe conditions. What I think is that the ALJ didn't agree that her agoraphobia was so limiting that she couldn't leave the house.
Every single day. What does it mean to have agoraphobia, but you can leave the house every day unaccompanied to go to work? I don't know. How is that consistent? I have really struggled with this, and I know that she credited, but I know that she says, I believe you have agoraphobia, but I don't see how that can be consistent with saying, I also think you can leave the house every day and go to work by yourself.
Well, under that rationale, Your Honor, though, anybody who had agoraphobia and said they had a diagnosis of agoraphobia could be found disabled. And under our rules, we have to produce evidence that shows they are so functionally limiting. And what she did here is not produce that evidence, and it was a reasonable determination. You are not disabled based on, yes.
I will confess, I don't know a ton about agoraphobia, but is there reason to think that it's like depression? I mean, some people have depression and they are incapable of functioning. And some people have depression at a much less severe level. And so to say that someone has a diagnosis of depression is really only the first step in the question. You could have it to such a degree that it was debilitating, but you could also have it to such a degree that it is like not debilitating. Lots of people that like function in society have depression at some degree, and it's managed or not managed, or as Judge Gregory mentioned, sometimes people just suck it up and deal with their problems. Is there reason to think that agoraphobia is different than what I would say sort of my common knowledge of mental health challenges is?
Is it okay if I answer? I see I am over.
I'm
Yes,
sure
you
Terry
may.
Gregory
Yeah.
would be happy for you too.
You may.
Oh, okay. I think that, it's not based on a diagnosis. There could be varying degrees of agoraphobia. Here, the claimant actually reported improvement with her agoraphobia, told her primary care doctors that the medication was effective. She stayed on the same medication for years at a time with not a lot of changes. So like other mental health illnesses, there could be varying degrees. Certainly, there could be somebody that shows this court that they really truly never leave their house and they're so panicked. But we just didn't have that here. We had somebody who reported improvement in her anxiety with her medications. She was leaving her house, and all the other stuff that I've told you before, prior to this. And the ALJ looked at all of that as a reasonable fact finder, and that's why we asked this court to affirm.
Thank you, counsel. You have some time reserved, counsel?
Thank you, Your Honor. I do want to respond to a few of the points that were made. First of all, the issue about counsel for the commissioner said that she went to her doctor's appointments, her primary care visit, so that shows that she could leave the house. But she never said she couldn't leave the house. She said she couldn't leave the house without somebody with her. But I want to go back to Dr. Broman Folks, the consultant. He didn't know he didn't have her primary care records. I'll concede that. But he knew, and it's in his report, that she left the home to go visit a friend monthly, accompanied by her father. He was aware of that. He was aware that she wasn't just closed up in her bedroom. So this was.
Yeah, I don't have any doubt that an ALJ, I have literally no doubt at all. In fact, if I was the ALJ, I would probably find that this woman was disabled, right? But that's not the question, right? I mean, I understand how your doctor came to the conclusion. The challenge I've got is there is some evidence on the other side of this that is a little hard for me to get my head around. How I just sort of say I think I got a better handle on this than the ALJ.
Well, I'm not saying that I have a better handle, Your Honor. I'm saying that the consultative psychologist, who's an expert in the field, did. One of the things that I found amazing here in the decision was the ALJ said that she found persuasive the two state agency psychologists who did not meet, or the psychological experts who did not meet with Ms. Calhoun, but just reviewed the records. Their reviews were 2 months apart. A total mismatch between their records, but she said they were persuasive. But the one that she said that was the most persuasive was Dr. Harrison. So Dr. Harrison, if you look at her report, says that Dr. Broman Folks, the person who met with her, who is their consultant, not mine, it's not Ms. Calhoun's, it's the person they sent her to, that his evaluation was completely consistent. She said, Harrison said it was completely consistent with the evidence of record. So the ALJ, who said that she was persuasive, found that that she was persuasive, but Broman Folks wasn't, even though Harrison said he was. I mean, it's a trap, I guess. I want to address a few things in my last few seconds here. In terms of logic, is it logical to say that a person who goes to aquatic therapy doesn't have leg problems? I mean, that makes no sense. Ms. Calhoun said she went 5 times, by the way. So over 2 years, she attended 5 times the aquatic therapy. The definition of agoraphobia, which I think has been talked about a lot here, and I agree. I mean, if it's a severe impairment, then it significantly limits her. So what is the significant limitation of agoraphobia if it's not that she can't leave her house? Thank you very much. I'm sorry.
Thank you, counsel.
My time's up, sorry.
Thank you both. Well, unfortunately, we can't come down in our normal custom to greet you and handshake, but know that the virtual one is just as hearty and all right. Council can hear and see everybody?
Yes, Your Honor.
All right, great. Good morning, Ms. Carlin. You can proceed.
Thank you, Your Honor. May it please the court, Pam Carlin for the appellants. The command of the 26th Amendment is simple and clear. The right of citizens of the United States to vote shall not be denied or abridged by any state on account of age. But South Carolina does precisely this in Code Section 715-320B2. As our Second Amendment amended complaint states, South Carolina allows voters over age 65 to choose freely in each election whether they want to vote in person or by mail. It refuses to give citizens under age 65 this same unrestricted choice, thereby abridging their right to vote. Now, I want to be clear. We agree with the state and with the district court that no one has a freestanding right to cast an absentee ballot. States today limit who can cast an absentee ballot in all sorts of ways. But what the Constitution provides is that there are certain reasons a state can't restrict who gets access to an absentee ballot. That includes they can't limit it on the basis of race under the 15th Amendment. They can't limit it on the basis of sex under the 19th Amendment. They can't limit it on the basis of whether somebody pays a poll tax under the 26th Amendment. Or here, they can't limit it on the basis of age because of the 26th Amendment. So what we seek in our complaint is to give appellants, and here I'm quoting from paragraph 22 of the complaint, the same right to vote by absentee mail ballot as that afforded to voters over the age of 65. Now, I hope that we fully address the court's questions about standing in our supplemental brief. So unless the court has questions on that issue, I'd like to turn to the merits.
I do. So help me understand. On page 2 of the brief, you say that when the disadvantage implicates harm specified in the Constitution, that disadvantage is sufficiently concrete. And you're quoting or partially quoting TransUnion. And I guess where I'm troubled, and I'm just trying to figure out how this works, that what TransUnion actually says is not is, it says it can be. And I think what's the change you've made is to transition from it is concrete to it can be concrete. But you have to have this additional showing that it's like certainly impending, right? I mean, the court there in TransUnion is talking about cases like Pleasant Grove, right, where they had applied to put the monument there, right, where, you know, cases like the Church of Leukemia, where they had said they were going to do the sacrifices, right, the Association of General Contractors, where they said we would apply for these set-asides if we could. Help me understand why you think just the mere existence of this, harm specified by Constitution without some showing that it's certainly impending, i.e. a declaration that I will vote absentee in the next election, why that's sufficient to show that it's sufficiently impending harm. It's the type of harm that could qualify, but you have to have something that shows it's impending. And I don't mean that to be hostile. I'm really trying to understand how these fit together.
No, Your Honor. The point that we're trying to make is the denial, the right that our client has is the option to choose in each election whether to vote absentee or by mail, because that's the option that citizens over the age of 65 have. And as we explain in the second part of our supplemental brief, it can't be that our clients have to wait until the particular election, because if they wait until the particular election, the Purcell principle means they're not going to get it in that election. Now we're past that election and they have to figure out what future election. But the whole point of allowing people no excuses absentee voting is to give them an option, and the denial of that option has already occurred. Now,
why isn't that? That seems like inconsistent with like the Association of General Contractors case, right? It's not enough to say that you want the ability or the option to choose whether to apply for the set-asides, right? You have to say that you would do so, right? In Lujan, it's not enough to say, I want the option to choose to go to Acadia National Park, right? I don't, that's not enough. You have to express like that it's impending, that I would go. Like this option to choose idea, it seems like to me, would swallow all of the cases, because in every instance we say, like, I want the option to choose to protest, right? But we say, no, you have to show that you would be protesting but for the regulation, right? That what you're saying just eliminates this certainly impending piece with all of the constitutional cases.
I don't think that's correct, Your Honor, because here the question is South Carolina law gives a right. And the right, if you look at section 320B, is the right to choose in each election whether to vote or not to vote by mail. And if you require people to identify the particular election ahead of time, one of two things is going to happen.
So I totally understand the practical concerns, and I get it, right? But I get it. There's a practical problem here, but I still have to be able to say, I mean, I've got to be able to write something, or my colleague, somebody has to write something that says why there is a certainly impending harm. And it seems odd to say that the harm is just the right to choose, because that would be true in every case, right? It is, the right to choose how to protest, right? If they barred pamphlets, well, I'm not going to do a pamphlet, but I'd like to have the option of using a pamphlet. Like, that would eliminate any of the sort of certainly impending obligation that we have in all of these constitutional cases. Like, everyone that I looked through that you cited, right, there's an actual expressed intention to do something.
Yes, and our clients have alleged in the complaint that they voted absentee in the past, and that they would like to do it again in the future when it is the appropriate way to.
And so
vote.
you think in Lujan, if I said, I have visited national parks in the past, I will visit national parks in the future, and it may be one day that I want to visit Acadia. And so I've got a sufficiently concrete harm with respect to something that's happening in Acadia, because I've done national parks in the past, I'll do national parks in the future, and maybe, I don't know, it's possible I might want the choice to go to Acadia. I think the Lujan court would laugh at that.
No, Your Honor, that's not what our allegation is. Our allegation here is about a discrimination claim. And so let me give you an example, which is you have a government cafeteria in the basement, and they give out menus that say you can have apple pie, blueberry pie, or cherry pie. They give those menus to you because you're male. And then Judge Harris goes down there and they give her a menu that says you have apple pie or blueberry pie. At that moment, she has suffered a concrete injury if she says there will be points in the future. I don't know what I'm going to order today, but I know I want to have the same menu given to me that Judge Richardson has. That is a concrete injury. And that's why we believe we have standing here, because we have a concrete injury that cannot be left.
And your point of that is you do your view, and then I'll stop because I know you have lots of other things you want to talk about. But your view is that in that story, it's okay for Judge Harris to simply say, I don't like chocolate pie, but I might one day want the option of having chocolate pie. I don't remember what the third option
No, that's not our allegation. Our allegation is I've eaten cherry pie in the past. I like cherry pie. I don't know what I want to order for lunch tomorrow, but I need to know whether I have a right to order cherry pie or not, and I need to know that now. That's what our allegation is. So let me turn now to the merits, which is that everyone here agrees that there was discrimination. The district court on page 104 of the joint appendix says section 715.320b draws a distinction based solely on age. So the remaining questions are whether that discrimination constitutes an abridgment and whether that abridgment is an abridgment of the right to vote. And we think the answer to both of those questions is yes. So let's start with abridgment. There are 4 amendments to the Constitution that use the phrase shall not be denied or abridged with respect to the right to vote. And the Supreme Court has interpreted abridgment with respect to 2 of those. And these are all identically phrased with the 26th Amendment. First, with respect to the 15th Amendment, in Bossier Parish, the Supreme Court says that the 15th Amendment is not about comparing the before and after to a particular group. Rather, it's comparing, as Justice Scalia's opinion for the court says, discrimination more generally. And the court then quotes Rice against Cayetano, which is a case where the Supreme Court said that the constitutional guarantee is against discrimination. So abridgment doesn't look to time one and time two. It looks to group one and group two. And a statute that makes it harder for voters who are young to vote than voters who are old to vote is a statute that abridges the right to vote. That same construction is what motivated the court in Gwynn against United States. Oklahoma had a literacy test that was, the Supreme Court said, totally legitimate. But it then gave white voters a workaround, which was the grandfather clause. They could essentially get an easier path to the polls. And the Supreme Court had no problem saying that that violated the 15th Amendment. And here, it's the same thing. Voters who are over 65 have an easier path to the polls. They can vote by mail. Now, with respect to the 24th Amendment, the Supreme Court is even clearer in Harmon against Fresenius, which involved a Virginia law that said that if you paid the poll tax, you could vote, but if you didn't pay the poll tax, you had to file a certificate of residence. And the Supreme Court says on page 542 in Harmon against Fresenius that this requirement constitutes an abridgment of the right to vote by reason of failure to pay the poll tax. And what the court then went on to say is it doesn't matter how small that extra requirement is. They said it might not be burdensome at all, but just having that discrimination is enough. So when it comes to the 26th Amendment, it is clear that young voters are worse off than older voters. They lack one of the options that older voters have, and that by itself is an abridgment. Now for the right to vote. Here, the district court erred in thinking that the discrimination at issue here somehow doesn't implicate the right to vote, but implicates only the so-called convenience of voting by mail. The Supreme Court's 15th Amendment case law rejects that argument. The statutory definition of the right to vote rejects that argument. And the district court erred, I think, by relying on a case that didn't involve one of the voting rights amendments at all, but was McDonald against Board of Elections in Chicago. And I think the key thing to take away from that case is that that was a case, as the Supreme Court itself later said in O'Brien, that was rested on a failure of proof. The claim in McDonald was not a claim of abridgment. You won't find the word of abridgment anywhere in that decision. Rather, it was a claim that if you don't let us vote absentee, we can't vote at all. And the Supreme Court says in McDonald that nothing in the record supported that allegation. But on top of that, I think there are three other reasons the district court's reliance on McDonald was erroneous. First, McDonald predates the 26th Amendment, so it didn't consider whether that amendment has an absolute bar on discrimination on the basis of age. Second, as I already kind of alluded to, the 26th, the word abridgment doesn't appear anywhere in McDonald, so it doesn't actually bear on the issue here. And finally, the Supreme Court's own post-McDonald case law shows that even if there are alternative ways of voting, a discriminatory rule regarding voting by mail can violate the Constitution. So let me turn very briefly to our 14th Amendment claim.
I'm sorry, Counsel, before you switch over to the 14th Amendment, I just want to, so two other courts have looked at this, right? And they have both said this doesn't violate the 26th Amendment. And I feel like, just reading between the lines a little bit, not really even, what's driving them is this kind of intuitive setting of a baseline. Like, look, voting is voting in person. That's the baseline. All this law does, it's more like, doesn't invidiously discriminate against anyone. It's not trying to stop anyone from voting, or it's not trying to make it harder for anyone. It's more like we're just making an accommodation for people who need a little special help when it comes to voting. And so what is the harm? Your right to vote is not materially impaired by the fact it's more like affirmative action than like invidious discrimination. What's your problem? You can make an accommodation for one group that needs it without discriminating in any invidious way, at least against the other group. And that seems to be kind of what's driving these courts. And I guess I want to give you a chance to tell me why that's wrong.
I think you've described exactly what's driving the courts. The problem is the text of the Constitution doesn't allow them to do that. It's a little bit like what Justice Scalia said in Heller and what Justice Justice Alito said in McDonald, which is the enshrinement of constitutional rights necessarily takes certain policy choices off the table. And the policy choice that's been taken off the table by the 26th Amendment is having affirmative action for older voters relative to what you give to younger voters. So we understand that impulse entirely. We're simply saying the Constitution prohibits it.
Can I just follow up on that, Judge Gregory? Do you mind?
Yes, sure, go ahead.
So, again, along the same lines, just a sort of chance to respond to this version of it. I understand there's this language discrimination in Scalia's Reno opinion, but he seems to really focus on the idea that abridgment requires a comparison, and he gives two possible comparisons there, neither of which is the group one, group two that you've suggested, but instead, at least I would read it, and I want you to have a chance to respond to, sort of saying either one, that a bridge is by definition comparative, and one comparison is the status quo, and that's a Section 5 kind of context that makes sense. And the other one is sort of some maybe platonic ideal of what the right to vote ought to be, I think is the phrase that he uses. Like, he didn't use platonic ideal, but what the right to vote ought to be, and that's the comparison. So that there's some core right to vote that doesn't implicate every burden that might be placed on it or every variation that might exist. Tell me why I shouldn't read Reno that way, or why, in other words, why do you think the right comparator is necessarily like the least restricted group as opposed to the status quo or what the right to vote ought to look like?
Because if that proposition were correct, then it wouldn't violate the 15th Amendment for South Carolina to say, we're going to have 20 hours of early voting for white people and 10 hours of early voting for black people.
All right, fine, but that would violate the 14th Amendment. Like, it doesn't violate, so except for a minute, I get the argument, right? But except for a minute, okay, it leads to a little bit of an odd result in the 15th Amendment. That's not terribly concerning because it would be plainly barred by the 14th Amendment. So like the fact that we only have a belt and no suspenders, maybe it does cause us problems, but maybe it doesn't cause us concern. Tell me why, like, non-consequentialist reasoning suggests that that's not the right way to read what the Supreme Court has told us to do.
Because what the Constitution, the text of the Constitution tells you to do is not to permit discrimination with regard to voting, however.
Well, wait, just one second, because the Constitution doesn't actually say you cannot permit discrimination, right? That's actually not what it says, right? It says you cannot abridge the right to vote on account of age, which is not to say that it is a bar on all discrimination. I'm totally fine talking about the text of the Constitution, but don't put the word discrimination in there and say that's what the text demands.
It is a bar in the text of the Constitution on denying or abridging the right to vote on account of one of these group memberships.
Yep.
And the Supreme Court has repeatedly said in Rice against Cayetano, in Gwynn, and in Bossier Parish that discrimination is what they are forbidding. They are forbidding racial discrimination you sex-based discrimination in voting, taxpayer-based discrimination voting, and age discrimination in voting. And honestly,
so your view is you say we should just read abridged to be they shall not discriminate on account of age.
That's
what abridged means.
With respect to the right to vote, if one group has less of a right to vote on account of age than another group has, their 26th Amendment right has been violated.
Thank you, Judge Gregory. I'm sorry for running over.
No problem. Thank you, Counsel. Mr. Green?
Thank you, Judge Gregory. May it please the court, good morning. I'm Tracy Green. I'm representing the South Carolina Election Commission defendant, but I'm arguing today on behalf of all the respondents. I'll rely on my brief for matters not discussed today. Let me touch briefly, I think, on the standing argument and then proceed to the 26th and 14th Amendment arguments. We would agree there's there's really not a concrete injury alleged or a particularized injury alleged. It is just a matter of voting for convenience. They say that candidly, but I don't think I'd assert under the court's precedents that's not enough. There's got to be something a little bit more particularized showing them. Otherwise, they are just complaining because they are a part of the group in general, and they don't really have any of them particularized injury that's different from anyone else in that group.
You're saying that if an entire group suffers an injury, each member of the group doesn't have standing because it's not particularized because lots of people suffered the same injury? Is that your argument?
I would submit that that's how I read the more standing certainly has changed in my mind in the last few years, but I would assert that the more recent precedent from the court. I don't think any of the parties cited it. The Opie-Otinian case seemed to get into that, where just being a part of a group that was supposedly disadvantaged is not enough. You've got to show something more particularized. I don't think anybody cited that case, but you've got to show something more particularized that you were injured or somehow suffered a disadvantage individually. And
Counsel,
I don't think we have that here.
Counsel, do you agree that to sort of, I think, get to this point, that if one of the plaintiffs filed a declaration that said, if I was able to, I would vote absentee in the 2026 primary or 26 general, that would create a sufficiently impending concrete harm that they could bring suit? As long as they said that, right, that would suffice, because that looks like cases like the Association of General Contractors, where they said, if I could apply for the set aside, I would, right? Where, the church saying, we'd sacrifice animals if it wasn't against the law. That sort of would satisfy this sort of like sufficiently impending point.
Your Honor, I actually, in the circumstances of this case, I'm not sure that would be enough. I don't know what the plaintiffs can show, but here's why I'm answering the question that way. They have so many other options to either vote absentee or vote early or vote in person. So, and those are minimal burdens to go to the poll.
Maybe that's a merits argument, but I don't understand what that has to do with standing.
Because
they've said we don't qualify for the other absentee provisions. And so if somebody said, right, just like they did in the Association of General Contractors, I'd apply for the set aside if I could, right? If somebody said I'd vote absentee if I could, that would suffice. I mean, this is like a really minor point. I don't mean to belabor it.
Yes, sir.
Because it seems like super simple to get around, but it seems like just like in Lujan, you got to say, I would visit the park, right?
Yes, Your Honor. No, yes, no, I understand that. What my argument is, some have voted absentee when they otherwise qualified to vote absentee in the past. So they can vote absentee out of the county, work, whatever. If they otherwise qualify, they have other options, and they can also go to early voting. Those, in my mind, respectfully, are minimal burdens that the courts have not said are an impediment. So to me, there's got to be an injury that shows that they can't vote absent this. But at a minimum, there has to be something more than is in this complaint. I would absolutely agree with that, and I would submit there is not enough to get them over that hurdle. I also would just briefly argue before proceeding on, I'm not sure that the remedy they want, which is to make it available to all, this court can't grant that because the court won't rewrite a statute.
I don't think that's what they're asking for. I thought their brief was really clear that what they want is a declaratory judgment, I guess, saying you can't do this. You cannot discriminate based on age in making absentee ballots available. Fix it however you want, level up or level down, but you can't do this.
In paragraph 6B of their second amended complaint, they say we want convenience voting.
6B of their amended complaint says we want convenience voting?
Yeah, JA 24, each plaintiff wishes to vote by absentee ballot in any election where
That's not
that
the
is.
relief they're asking for, counsel. Anyway, maybe you want to move on to your next point.
Thank you, Your Honor. Thank you. So, yes, with that, our argument in respect to the merits of the 26th and 14th Amendment, the 26th Amendment first, the right to vote is, I think, as Judge Harris, you touched on, I think we submit the right to vote as the baseline, which is the right to go to the polls and cast a ballot. Absentee ballots are a privilege that are extended as part of generally the state's power, either on its own elections or, if not preempted by Congress.
So counsel, with the same,
the
I
manner of
assume,
voting.
counsel, I assume, so you would say the same about like early voting. It would be fine if the state had a rule that said, you know, we're going to have actually no early voting, except we'll have early voting for white people, 2 weeks. That would not violate the 15th Amendment under your understanding.
Sorry, a fire truck is going by me. Your Honor, no. First of all, that would be an equal protection argument.
But I guess I'm asking about the 15th Amendment.
The 15th Amendment, if the right to vote, I think it is going to hinge upon timing. If that right to vote as convenience voting has not been extended before, it might not be a 15th Amendment issue.
So you want me to write an
Unquestionably
opinion? Hang on, counsel, because this is a serious concern I have. You are asking me to write an opinion that says my state of Maryland, I'll make it personal for me, tomorrow could pass a law that says we're going to have voting on election day, except all white people can vote early 2 weeks before election day. 14 days extra for white people. And I'm going to write an opinion that says that's fine with the 15th Amendment. Because that strikes me as a hard ask.
Well, some of it would depend upon timing and the nature of the thing. But
what the nature of what thing?
Well, for instance, if the right to vote had been extended before and then was being taken away, then I think that is a 15th Amendment. But if the right to vote is a core,
I mean, I think the one thing the Supreme Court made really clear in that Justice Scalia opinion that my colleague was talking about is that you don't apply the retrogression, time 1 versus time 2 analysis under the 15th Amendment. That's what the court says. That's for pre-clearance, but that's not how we look at the 15th Amendment.
And that is correct. And and Section 2 would be different, and that would be on the 15th Amendment. And it might be a violation of Section 2 of the Voting Rights Act, which is a little bit broader than the 15th Amendment. Okay. But if the right to vote is the right to go to the polls, and I think the Bernabich decision touched on that, where even as late as 1980, the right to vote was generally the right to go to the polls. It wasn't really involving absentee or anything like that. So again, if the right to vote is a minimum of going to the polls, I don't know the nature of the violation of the 15th. It is absolutely a 14th Amendment violation. I am not advocating for anything that says that's okay. I think the nature is how that's stricken down.
But South Carolina has broadened the idea of voting beyond just going to the poll, hasn't it?
I'm sorry, Judge Gregory.
South Carolina has broadened the idea of voting to just being able to go to the poll to vote. It has broadened that, hasn't it?
It has extended in some instances with respect to early voting, with respect to, again, there are a number of absentees.
Let's talk about this respect right here. 65-year-olds.
Yes.
I think you used the word, that's a privilege?
That's a privilege under our argument, yes.
So you're saying, so if it's a privilege, then it's somehow protected from discrimination just because it's a privilege?
Your Honor, I think here a privilege, I think, yes. And I think it's a privilege because it is just.
But if that privilege changes your access to voting, didn't that have to go through the lens of the 26th Amendment, the no discrimination based on age?
Well, our argument is based on these facts, and here that really hasn't changed their access to voting because they can still go to the polls. Persons under 65 can cast the same ballot. They have the same rights they had before.
No. Access to voting is more than the fact that I can hobble there to. That's like saying, well, I'm going to change it to one polling place for the city and a very prominent, rich place. So everybody else has to leave their neighborhood and come to that one place. You're saying because you can still vote. We haven't changed that. That's just a privilege. We're gonna put it in one neighborhood. And that'll be fine.
I think how polling places are set up would be a little bit different. I mean, if it's based on race or sex and governing the right to vote in that, yes, I think that might be problematic then, because you are impacting
And what
people's right
about
to act.
age? What about age too? That scenario, race, sex, now age under the 26th Amendment, right?
I don't, what I'm not sure I understand the question, Judge Gregory. I'm not sure how the age
I'm
makes
just
the
saying,
difference.
you brought up as a privilege, but that privilege implicates access to voting. You have made it easier for a group to vote based solely on their being more than 65 or older. Isn't that right?
That is
That's all
correct.
they have to show, as a birth certificate or whatever, and they can do that. That's access to the poll.
We submit that that is not access to the polls in the sense that persons under 65 and over 65 can still go cast a ballot the same as they could before.
So do you think the state, because it's a privilege, could charge? Like you can vote absentee, but it costs $100? I mean, I assume
No.
you think that, why not? Because
No, because then well, I'm not sure. I think that's a 14th Amendment question.
no, it's not, because income, wealth, it's not a suspect classification. They can just say it's expensive. I'm telling you, running this absentee ballot thing costs a lot of money. We need to defray the cost. So $100. Because you would say the poll tax amendment doesn't apply because it's just a privilege and you can still show up in person.
I believe that wealth was held to be in Harmon or which one of those Supreme Court cases. So I think wealth is, and that was why the
Not as a
poll
general
tax was
rule.
stricken.
Okay.
Was
Yeah,
stricken
not as a general rule. So you would say voting is different, that.
I think the court applied it differently
But it wouldn't
the
count as a poll tax. It would not be prohibited by the.
I might make an argument that it's a poll tax, but it probably isn't.
I think you'd have to say it isn't because you said it's just a privilege. So you haven't abridged the right to vote because you can still show up in person if you don't have $100. I mean, it's the same language in the poll tax amendment.
That may be right. That part I've not thought through, but I don't think it would be a poll tax, but it probably would not be. But again, I think you've got a 14th Amendment. Let me circle back to your original question too, Judge Harris, if I might. There might be, part of our argument too is that the 15th and 19th Amendment, and there's not a lot of 19th Amendment authority, doesn't really readily extend to the 26th Amendment. This court in Lee touched on that. I think that was a voter ID case, if I remember right. It may be that because of the nature of the mutable characteristics that we're talking about with sex and race, that what you described about early voting and the like, that might very well make it a 15th and a 19th Amendment violation. The 26th, that's not an age across the board. It's sort of something that changes over time. And while the language of the three amendments is the same other than age or the qualifier, the Supreme Court certainly has applied age differently than race and sex. And we'd submit that based on that time, the framework that existed at the time that the 26th Amendment was adopted, it really was kind of taking that into account. And that's sort of the way it should be interpreted. And so it may be that something that's a 15th or a 19th Amendment violation is not a 26th Amendment violation. But today, our argument is.
I just say, counsel, I understand that argument that there's sort of a different history, particularly behind the 15th Amendment and the poll tax amendment, sort of invidious discrimination. But I feel that we are in an era now where kind of text overall, and so I do think it is. I feel like in an earlier era that would have been a very sensible argument, but these days it's kind of like text of sort of formal textual analysis. And so I am having, one of my concerns about your argument is that I am having a lot of trouble formulating an argument consistent with text that would allow me to say what you just said. I mean, when they drafted the 26th Amendment, they used the same text as in the 15th and the 19th, and they said, the legislative history makes clear, we get we're using the same text. We're trying to do the same thing. So I just think it is hard to sever them out the way you are proposing. And if you have, I don't know, if you want to try to address that concern, I would be all ears.
No. I certainly understand, because the Heller, on the one hand, instructs to, what was the right to vote contemplated, or what was the right contemplated at the time the amendment was adopted, and that hence our argument that the right to vote was the right to go to the polling place. But when it adopts the language from the other amendments, it does ask the question, how does that extend? And I do understand that. And that is why we've argued that we believe that based on what was the right to vote as it was understood at the time of the 26th Amendment's adoption is the same right to vote historically, which was the right to go to the polls.
Can I ask you, your argument is very broad. And I have to admit that I wasn't prepared for some of the positions you're taking today, but I want to bring you back more to maybe where the Seventh Circuit and the Fifth Circuit were on this issue. And this sort of intuition that I was discussing with your colleague, like, look, nobody is targeting anyone here. This is just an accommodation for people who need it. What if instead of this law, a state had a law that said everybody can automatically vote by absentee ballot? Everybody has the option in every election to vote absentee, except for people who are 18 to 21. And let's just assume it's a college town. And, they're just like, no, everybody else can vote absentee, but not the college students. But they define college students as 18 to 21. Would that concern you at all, or it's still whatever, it's a privilege, and if they want to extend the privilege to everyone who is over 21, that's fine?
That one seems, and that was absentee, right, Judge Harris?
Yeah.
I just want to make sure. That one seems different to me, but it is a privilege that's not been extended before. The difference to me in part seems there that you've extended it so broadly, except for a small subset, whereas, and maybe that touches a little bit on the 15th and the 19th distinctions that we were discussing.
But why would it matter for your theory? The reason I asked the question is, yeah, sure, the intuition suddenly seems a little bit different, but I don't see how your theory can accommodate that. If the theory is a privilege, so long as you are entitled to show up at the polls on election day and cast a ballot, all the privileges can be restricted based on race, age, gender, whatever.
Frankly, if the right to vote is the right to go to the actual polls, that might not be directly. If you had it and you took it away, that might be a violation of the 26th Amendment. But if the right to vote,
and you might also say that it fails Anderson-Burnick rational basis review too, right? That if you identified 18 to 21 and said everybody else gets absentee, but not, these 3 years worth of people.
Oh, you'd just be like, no, you'd be like, well, college students, whatever, they take 2 classes a week. They have time to get to the polls on election day. I can imagine rational reasons for saying people who are 18 to 21 in this town, by and large, we're allowed to paint with a broad brush. They've got more time on their hands.
Well, I can see, again, let me try to answer both questions. I think the Anderson-Burdick test, I could very well see that applying to cause a problem with that, because that's a different reason, and you are touching on the right to vote. But, a lot of the early 26th Amendment cases involve students and their residency requirements and trying to restrict that. So I can see where the situation you describe would create problems with that, because really what you're trying to do there is abridge the right to vote, because they can't vote. They may have problems voting in person during that time period because of their residency. And so what you try to do then will make it easier for everybody else to vote, but not there.
So you
might have issues there. And I think there was one case, and the name eludes me at the moment, but I think there was, and I see that my time is expiring.
Go ahead. Go ahead.
So I guess I was just, I really do think this is kind of this is at least important to me. Do you have a theory? Like you are saying, okay, that actually might be a problem under the 26th Amendment. Do you have sort of a rule you would want us to adopt where you win your case, but some other state might not win the case where they say everyone can vote absentee ballot except for the 18 to 21-year-olds? Is there a rule we could adopt that would distinguish those two things?
A rule to distinguish those doesn't come to mind there, because what I'm thinking is what we were discussing, Judge Harris, would be more of an as applied, in that while the law says 18 to 20, if it's a privilege, then it's not directly impacting the right to vote, but because of the residency issues and the inability or difficulty or
I see what
time
you're saying.
of students, then you might not be able to get there, in which
Okay.
case, as applied, there's probably an impact to the actual right to get to the polls and cast a meaningful vote that counts. So,
Mr.
to
Green,
me,
you-
it's as applied. I'm sorry, Judge
Mr. Green,
Gregory.
you concede that this is an abridgment, but you said it's okay as long as the abridgment does not result in a person cannot vote. Is that right? Isn't that your position?
I don't know that I would concede that this was an abridgment, because
Well, you have
our-
to be, right? To some degree, you're changing the access to voting. Otherwise, the
Well,
whole point is that the whole idea is the 26th Amendment says everybody can vote, and if everybody does it at the poll, then everybody does it. But when you change these, what you call privileges, to make that easier for one group and solely based on their age, that has to be an abridgment.
No, we don't submit it as an abridgment because that right was never extended before. So we have said, for purposes of the 26th Amendment, we submit that is not an abridgment.
It was never said before. I mean, my goodness, we are AI generation. We're changing as we speak in terms of a world. You're saying is whatever in the future you come up with, it doesn't make any difference because you never had that before. Like, so for example, you may get to the point 65-year-olds can just blink their eyes and AI vote, but everybody else has to come to the polls. That's fine because you never had that before. I don't understand that. We submit that it's absentee voting consistent with the Supreme Court Your
precedent.
argument almost sounds like the argument in Plessy. That was the argument in Plessy. They said, listen, it may be discrimination, but the train gets there at the same time for everybody.
Respectfully, I completely disagree with that, Your Honor.
Well,
This
isn't that
is
the
a matter
same
of
thing? The train is the analogy to voting. So how making it easier and more comfortable with somebody, how they sit on the train makes no difference, whether it's based on their race or whatever. That was race. This is not race. But that's really what you're saying. As long as the train gets there, meaning you can vote, everything else is just a privilege, and therefore you never had it before, and therefore it doesn't implicate or violate the 26th Amendment. That's your argument.
With respect to
Just own up
age,
to it.
yes,
That's
with
all.
respect to age, that is our argument in this
Okay,
case.
that's what I want to make sure. All right.
Yes,
Thank
in
you
this
so
case.
much.
Yes,
Thank you so much.
thank you.
Thank you, Counsel. Mr. Carlin.
Thank you. Excuse me. Thank you, Your Honor. I have 4 basic points to make. The first is that absentee voting in South Carolina is not a privilege, it's a right. And if you look at Section 320B, it says that qualified electors who fit one of the categories, and here I'm going to quote from the statute, must be permitted to vote by absentee ballot in an election. So they have an enforceable right there. It's not simply a privilege. The second point I want
Do you think, counsel, that however we think about the right to vote, are you advocating to sort of having state law be the sort of definitional guide so that the right to vote might look different in South Carolina than it does in, the great state of Maryland based on how the state defines it? I mean, are we really looking to state law to define the right to vote in the Constitution?
You're looking to state law to figure out what the right to vote means there. And if you look at the Supreme Court's decision in McDonald, they
Yes,
said,
so under the Constitution, so you think the words "the right to vote" in the 26th Amendment vary by state?
In the following sense, yes, which is in a state that doesn't allow anybody to vote absentee, the right to vote is only a right to go to the polls. In a state that allows people to vote either at the polls or by mail, the right to vote involves the right to vote by mail or at the polls. And the Supreme Court is quite clear about this in McDonald. They say the state has a lot of control over how the franchise is extended. But once it is extended, there are forms of discrimination that are impermissible, and one of those is race. The second point I wanted to make is just to clarify the remedy issue, which is if you look at JA 27, paragraph 22, that's where we ask for our remedy, and it is the same right. It's not a right to vote by convenience. A third point that I just want to
I'm sorry, can you go back to that? So what you're asking for is the same right?
Yes.
And so from, sort of the court's power, what you're asking us to do is what? Like, what would you have the order say?
So our opening brief says you should remand for remedial proceedings. It is up to the state.
Then what would the district court say, right? What would the federal court say?
The district court would say to the state, you must treat voters the same with regard to voting by mail, regardless of their age. You decide whether you want to extend this right to under 65 voters or you want to take it away from over 65 voters. Either of those is the state's option.
Wouldn't we typically do like...
Your Honor, in every voting rights case of which I know, and I've litigated dozens of them, the first option is always the state gets to propose a remedy that will cure the federal statutory or constitutional violation. And that's what we're asking for here. Give the state an option to cure the constitutional violation of discrimination on the basis of age in violation of the 26th Amendment. A third point I want to make is there seems to be this desire on the part of the state and perhaps on the part of some members of the court to say, of course, it would violate the 15th Amendment to limit voting by mail to whites or limit it under the 19th Amendment to women, but that would be just a 26th Amendment, 14th Amendment violation. And the Supreme Court is quite clear, the James Daniel Good case is the case that comes to mind immediately, to say things can violate more than one constitutional amendment. It would be passing strange to say that an amendment that expressly talks about voting and expressly talks about race is not violated while the general command of the Equal Protection Clause is. A third point that I wanted to make is with regard to standing. The plaintiffs in the AGC case, the Associated General Contractors case, said we bid on contracts in the past, and there are contracts we would like to bid on in the future. But of course, that's no more concrete than what our clients are saying here, which is you have to wait to see what the request for proposal is. You have to decide, do I have the resources right now? Is the price good? Before you decide whether to bid on that. And the Supreme Court could not have been clearer that the violation occurred here. Finally,
Counsel, can I just ask you a quick question about the standing?
Sure.
So, I did look at the complaints in these other 26th Amendment cases. It's a little bit different because that was during COVID. So those people just said, look, I would like to vote absentee. I really am genuinely just curious, given that this issue disappears, if your clients just submit a declaration saying, I would like to vote absentee. I mean, is it just that, genuinely they actually prefer to go to the polls if they can manage it and they just don't know right now whether they'll be able to comfortably manage it for the next election or not? Like, do they just want to reserve? Why don't they just submit a declaration that says that?
Well, the problem is, if you're asking why don't they submit a declaration that says, look, I don't know whether I'm going to want to vote absentee at some point.
No, I think that is what they submitted. Why don't they just submit one that says, I want to vote absentee?
Well, it wouldn't solve the standing problem if it has to be a future election at the time the court rules. Because imagine that our clients filed this lawsuit before the 2024 election. Suppose they said, we want to vote in the 2024 election. That election then passes. Now you have to point to a future election in which you would do it. You end up in this weird kind of capable of repetition yet evading review.
Well, what if they just said, I would like to vote absentee kind of period? It's more convenient.
Then you're denying them the right that they actually sought here, which is the same right to choose election by election.
Well, that's what I meant. So they may actually, this is not a trick question. I'm just trying to get my hands around. I did find the way the complaint sort of pled this part a little bit unusual, and I'm trying to figure out why. And that is a very sensible answer. I myself prefer to go in person if I can, and I vote absentee if it's inconvenient. And
Yeah,
they
I
may
mean,
just
look,
feel the same way.
I would prefer to be in Richmond and get the actual handshake.
Right.
But
Right,
for
voting in person is
logistical
fun.
reasons, it doesn't work so well.
Yeah, okay.
And I think that's really what our clients are saying is, look, there are elections in which I want to go to the polls. And this court may remember, because it was one of the things that was discussed in the North Carolina omnibus case that the court decided about 5 or 6 years ago, that there was testimony about the voter ID requirement there, that if you were over the age of 65, you could vote by mail and you wouldn't have to submit a voter ID. And a number of the witnesses who testified at trial, who were African-American witnesses in their 70s, said, we prefer to go to the polls to vote. So for those people to require them to say, I want to vote absentee at every election in the future, denies them exactly the choice they're seeking.
Okay.
And it's for these reasons that we ask the court to reverse the judgment of the district court and remand the case for remedial proceedings.
Thank you, counsel. Again, we won't be able to come down and shake your hands. I would prefer it to be that way too, but I'm glad that people are safe in terms of this weather, and know that we appreciate both of your arguments and your final counsel. Thank you so much. Take care. Mussenberg,
Good morning, Your Honor.
good morning.
Your Honor, good morning, and may it please the court. Simon Sandoval Motionberg for the appellant, Sunday Agahi. Yes, thank you, Your Honor. I think at the end of the day, once we get past the fact that certain things were done by email and not on the docket, which I'm certainly happy to discuss with the court, but I think sort of once we get past that, at the end of the day, this case represents a fairly straightforward application of Gay versus Wall, which is the Fourth Circuit case from 1985, which holds that for a district court to convert a Rule 12b motion to dismiss into a summary judgment motion, there must be a reasonable opportunity, and the reasonable opportunity requires that all parties be given some indication that that's what's happening. So what happened in this case was that after the amended complaint was filed prior to the filing of a motion to dismiss, a motion to dismiss was filed and fully briefed. Motion, opposition, reply. The court did not schedule oral argument on that motion. And then, in deciding the motion to dismiss, the district judge asked the government to provide both the underlying USCIS and administrative appeals office decisions at issue, and also the administrative record, right? So essentially provide to the court everything that's going to be provided, because this is an APA case, it's going to go solely off of the administrative record. The government promptly provided the USCIS and the AAO decisions, and then said, Your Honor, with your leave, we're going to need another 30 days to compile the administrative record. The court replies, sure, that's fine. You can have another 30 days. And then about 15 days thereafter, issues a memorandum opinion granting the motion to dismiss on jurisdictional grounds 12b1. So there was no reasonable opportunity for appellant, the plaintiff below, to respond, to brief, right? And of course, the memorandum opinion is loaded up with quotations from the USCIS and the AAO opinions, and really relies on those. So for that reason alone, I think a remand is appropriate so that the parties can have the opportunity to brief this case, based on the actual record before the court. I think Appellee's only response to that is, well, you're raising a new issue on appeal. You can't do that. And of course, it's correct that you can't raise a new issue on appeal, but precisely the whole problem is that there was no opportunity to raise this before the district court. The only way to do that, I suppose, would have been through a motion under Rule 60, but that's not something that's available as of right? That's sort of especially in a case of this nature, we're not alleging fraud, we're not alleging new material facts or anything like that. A Rule 60 motion would be very discretionary. And I think it's pretty analogous to the Santos-Zachariah case from the U.S. Supreme Court. And I confess we didn't cite this in our reply brief, but it's a 2023 case from the U.S. Supreme Court on the context of a petition for review from the Board of Immigration Appeals, in which the Supreme Court says, well, you don't have to exhaust discretionary motion to reconsider, right? You can, if your contention is that there was error, you can just take a direct appeal to the Court of Appeals, and you can raise that error before the Court of Appeals in the first instance. Might it have saved us all a lot of time if the attorney had filed a
do we
Rule 60
naturally
motion?
think that the agency exhaustion applies to like issue preservation? I mean, those don't naturally, obviously I haven't read Santos Zachariah, but those don't naturally like seem to ask the same question. Like one sort of a separation of powers concern, right? And am I help me understand why I ought to think about those two the same way? Such as we would, I mean, I think you're suggesting that we say any time that the district court has discretion, you don't have to raise that issue because you can raise it for the first time on appeal. That seems like a pretty broad line for us to draw.
No, I think actually my argument, Your Honor, is almost the reverse of that. It's the flip of that, which is to say, if this was a matter that was committed to the sound discretion of the district court, it would be an abuse of discretion standard on appeal. But the argument
but you're making the argument that because Rule 60 is only discretionary, you don't have to make that argument below. You get to make it for the first time on appeal. You're not required to ask the district court to do what it was plainly entitled to do, that is, reconsider its decision under this theory that you had. But instead, you can just say, well, Rule 60 has some discretion for the district court judge, so I don't have to preserve it there. I can sandbag it and just take it up.
Well, Your Honor, I don't think it's sandbagging here. I think
I don't mean that as a pejorative, right? I just mean as a descriptive matter.
I understand. I'm not familiar with any case, and the appellees certainly have not cited any case in which the Court of Appeals held that a Rule 60 motion was mandatory before taking a case up on appeal. And I don't, especially given the facts of this one, given, what we put in the record on the posture of the motion to dismiss with regards to the representation below, I wouldn't think that this is the proper case in which to introduce that rule for the first time, that a Rule 60 motion is mandatory, where we're arguing legal argument, right? Of course, if the argument is, some kind of factual argument, some kind of...
Can you address the premise too? Why under 12b1 they weren't entitled to consider these decisions?
Certainly, Your Honor.
I mean, again, if you go way outside the record, but these are decisions that are sort of integral to the complaints. You might say, like, that on a 12b1, tell me why on the premise is right.
So, Your Honor, I think that under 12b1, the, sort of leaving aside any, issues with authenticity, for example, which is certainly not an issue here, under 12b1, it can be considered integral to the complaint if it's a matter of public record, right? And so I don't think that...
What about a contract? I thought we sometimes consider contracts, like in a contract action, we consider the contract itself to be integral to the complaint, and it's not part of the public record. Where does the public record requirement come from? I don't really...
Yeah, I mean, this is just the case law on when a district court can consider matters outside the pleadings on a 12B motion. A 12B1, of course, takes two forms, right? It can take a facial attack on jurisdiction, or there can be a factual attack on jurisdiction. In a factual attack on jurisdiction, it's common and expected to include, supplemental material. You can have affidavits, you can have evidence, what have you. But this was very clearly a facial attack on jurisdiction, which is held. This court has held in several cases that a facial, Kearns v. U.S. 2009 being the leading case, that a facial attack on subject matter jurisdiction is held to the same standard as a 12b6.
Counsel, I'm sorry. I feel like I am just completely missing the premise here. So maybe with apologies, just explain. So this complaint gets filed and it says the agency made mistakes when it denied my application. And you're saying it's not proper for the district court in adjudicating that to consider the agency decisions. Is that the argument?
No, Your Honor. The district court can absolutely do that, and I apologize if I'm leaving that impression. But the means by which the district court has to do it is by giving the parties reasonable opportunity that it's going to do that, right? And the court did not do that until after all the briefing was in, and so there was no opportunity for the plaintiff below to respond to it, right?
Got the notice too late, because I think in your opening brief it was we didn't get notice. In your reply brief it was like, okay, we got notice, and I thought we were done with this question, but now the argument is the notice came too late.
Yes, Your Honor. I mean, candidly, the opening.
I understand. I totally understand.
This is the problem with doing things off of the PACER docket, right? I mean, this is why, especially if it's going to be so integral to the court's holding. It needs to be filed on the record. But in any event, we are where we are with regards to the briefing. The position at this time is that the plaintiff below needed a reasonable opportunity to respond to these documents. And, the only way by which that could have happened, especially given that the plaintiff, all the parties were under the understanding that the full administrative record was going to be filed, right? Because the court requested the decisions and then the administrative record. The decisions were provided. The government asked for an extension to provide the administrative record. The extension was granted, and then the decision was rendered prior to that. I think if this was a case in which, for example, the full administrative record was provided and then the court, sort of took its time, I think the government would have appellees would have a stronger argument that there was a period of time in which plaintiff should have filed a motion, right? Should have filed a motion for leave to file supplemental briefing, what have you. But here the plaintiff was caught completely unawares by the fact that a decision was about to be rendered. Everyone thought that more filings were going to occur, right? And then the decision would be rendered. And so for that reason alone, I think this court can find that there was no reasonable opportunity for the plaintiff to brief the, candidly one viable issue in this case, right, which is this marital cohabitation requirement, which, the agency as a matter of law recognized that they were wrong, right? I mean, the timing's very interesting on that. The administrative appeals decision in this case comes down, and then subsequent to that, but before all the briefing on the motion to dismiss, the agency actually flips its position on this issue, right, and says, you know what, actually, y'all are correct about this. We've been wrong all along. The statute does not require cohabitation during the marriage. It requires cohabitation at any time. So they flip their legal position on this. But then in this case, they don't essentially give him, the agency doesn't give him a new chance to show why, under the expanded, now correctly expanded legal standard, why he qualifies. That's, jumping forward to the merits of everything here, jumping forward to the merits of the APA, the underlying APA case. That's really what needed to happen here, was that the agency, when it denied the case based on a impermissibly narrow statutory interpretation, and then proceeded to expand its statutory interpretation as a result of district court orders around the country, the agency needed to give him another chance to show that he met the standard under the new standard. And in that respect, I would point out that the decision that matters here, as it were, is the AAO decision, because it's a totally de novo review. So the underlying USCIS decision is not really it's of interest in that it's relevant background, but it's not the decision that's being reviewed here. The decision that's being reviewed by the district court is the AAO decision.
Can I ask you a question? I appreciate your, I guess your clarification, candor, and saying like, look, most of what is in this complaint is about the weighing of the evidence. There's no jurisdiction, but we think you can pull this strand out where there is jurisdiction, this legal question. And I would just tell you that my concern is that if I look only at the complaint, I feel like it, just practically speaking, it is asking a lot of a district court judge to kind of pull this phrase out from the statement of facts. And in a context where, as you say, the agency has not yet changed its mind. So no one's sort of on alert for this issue. And there's no factual allegation that would suggest you're making this claim, right? There's no factual allegation that says, it's not like this one phrase is accompanied by a factual allegation saying, I actually did live with my spouse, but it was before we were married. I think it is asking a lot of a district court just looking at this complaint to kind of pull on this strand. Does your argument turn on the fact that there was also this brief, and that even though you can't amend a complaint from a brief, once you get the brief, you have more context for reading this one phrase in the complaint? Or would you be making the same argument even if this issue had not been raised in the brief?
Your Honor, I mean, I certainly would agree with Your Honor that the amended complaint is a mess, and the government sort of police correctly point out that there's basically 10 words in the amended complaint that sort of plead the legal issue that survives the 12b1 jurisdictional challenge, right?
Sort of,
as it were.
allude to it.
This is why we have briefing on a motion to dismiss, right? So that the parties can sort of point to the court what what they want the court to focus on, right? There is no question that if those 10 words were not in the complaint and the plaintiff below tried to raise this issue on briefing, there is no question that that would be completely impermissible. Although I would point out that that would give rise to very good grounds to give motion for leave to amend the complaint, which is another issue we have in this case, right? Did the district court abuse its discretion by denying motion for leave to amend? But here, it's in the complaint. I mean, it's
no, I agree.
Tough.
So I think we agree. If it's just in the brief, but these 10 words aren't in the complaint, no. And I guess I'm asking you, what if the 10 words are in here, but there's no brief, or the brief doesn't raise this issue? Are you still saying, and I'm just sort of cards on the table, my discomfort is, yeah, okay, I see it, but it's a lot to ask of a district court.
It is, Your Honor, and I think certainly I'm not going to stand before you and argue that this was a very well pled complaint, but I think it's just above the line, and I think that the function of briefing is precisely for that, right? There wouldn't be a situation in which a district court would ever be called upon to decide a 12b1 or 12b6. Solely by reading the complaint top to bottom and then not having briefing, right? And so therefore, it is certainly appropriate for the briefing to, point out to the court, here's what we think you can actually do in this case.
Judge Gregory, do you mind if I ask one follow-up to that?
Oh, no problem. Go ahead.
So what do I do about the fact that the petitioner bears the burden to show that any error is prejudicial? Both in the context of like whether it was adequately pled. So as question one, which is most related to Judge Harris's question, and then question two, sort of if we assumed through the line of suppositions here that it was adequately raised and that it was an error, what would I rely on to see how the petitioner met the burden to show that it was prejudicial? Right, because it's your burden, not the government's, to establish prejudice.
Yes, Your Honor. I just think that that's the type of question that ought to be reserved to the district court. I don't think that this court ought to be deciding in the first instance, whether the
We'll start with the first part of the question, which is, it's your burden. That means it's part of what you had to plead. What we don't see is anything that would support a prejudice piece in the complaint, right? If I'm reading the complaint to sort of understand, have you adequately pled a claim, right, effectively, and at most you've pled there was an error, but no suggestion of prejudice. Just at a pure complaint matter, how do I get over that bar?
I think that's to my mind, the pleading is just above the line of sufficient, but certainly if the district court found that it wasn't on the prejudice, that would be precisely leave to amend territory, right? There are certain elements here. You haven't pled one of the elements. We can't tell whether or not you're going to be able to plead one of the elements, leave to amend, because again, a facial 12b1 is always going to be held to the same standard as a 12b6. But I mean, I think just the way that this should have gone, right, is that the district court, when it requested those things from the agency, when it requested the underlying decision, and then when it requested the administrative record, needed to do one of two things, right? Either advise the parties, look, I'm going to enter a decision based on the decisions, right? I find that these decisions are integral to the complaint, and therefore I find that it's proper for me to take them into account. I'm going to render my decision thereupon. Please brief it for me. Here it is, brief, please. And at that time, if the administrative record wasn't in, for example, the plaintiff below could have, filed a 56D, right, and said, look, we're not ready for this yet because we actually need the underlying record, right? And then once the underlying record is in, let's just brief it all, right? Let the plaintiff show why, why the agency got it wrong. That's certainly one option the district court had. There's other options. There were a lot of ways that the district court could have done this right, in compliance with Rules 12 and Rule 56. But the way that the district court did it, surprising the parties with a ruling when the parties were expecting that the underlying administrative record was going to be filed, that little twist on it denied reasonable opportunity, right? In the meaning of Gay versus Wall. And I know I'm way over time at this point, but I do want to say that I think that to the extent that our reply brief didn't lean as heavily on Gay versus Wall as I'm doing now in argument, I would apologize for that, but we certainly did.
We should be used
preserve,
to it, because that's what has happened throughout the case, right? We're comfortable.
As the court knows, I was certainly not the lawyer before the district court, but we certainly did preserve that argument for review by this court.
Thank you.
Thank you, counsel. Mr. Young?
Good morning, Your Honors. I guess I'll first jump to this first conversation piece regarding appellant's first issue here about the district court, whether or not they exceeded authority in taking into account these decisions. And obviously, I don't have a response to Gay versus Wall today, because that was the first time I'm hearing of this argument. But pointing to page 11 of our brief, where we have two more recent fourth court decisions, and Judge Richardson alluded to this, which is the integral and authentic nature of documents that are taken into consideration by the district court in an MTD process. And here, as my colleague has alluded to, there's no question of authenticity. This is the USCIS decision. This is the AAO decision to dismiss the appeal. And the integral nature, the complaint is based on this USCIS decision. In the Doriety versus Crenshaw case of the Fourth Circuit in 2024, that case hinged on a body cam footage that was alluded to and used by both parties, and then was considered in an MTD situation. Here, it's not obviously not body cam footage, but we're not talking about a new document or something that was not specifically stated in the complaint. And so, yes, Gay versus Wall is a Fourth Circuit decision, but 40 years ago versus two recent decisions, Doynes v. Valley and the Durati case, 2024 and 2016, that say the district court has authority to consider these without motioning them to a motion for summary judgment. And I guess one thing to point out as well in this the Gay v. Wall case is I just did a quick lookup of what this case was about, and it was a decision that said, no, we should not be treating this as a motion for summary judgment because there was no notice, not a motion to dismiss treated as a motion or the reverse. So I think this case does not apply here. And I think it's pretty clear that the plaintiff appellant knew this decision was out there. That was what the complaint was based on. The argument that there was no notice to respond, briefing was submitted, yes, about 8 or 9 months. I think it was October of 2022 when the briefing was finalized. This email came out mid-June asking for the documents. Appellant's counsel had an ability at that point, previous counsel, I should say, Mr. Moshberg was not the counsel then, but they had the ability to challenge or question why the court was requesting those documents at that point. They did not do so. Once the documents were submitted to the court, they did not do so. And yes, we agree. It was not on PACER. It's a weird way for the court to work. But that's their authority to request those documents, and they did so. In the Fourth Circuit itself, that's not necessarily the issue here. And so with that point, just briefly touch on their third point in their briefing, which is the motion for leave to amend. Mr. Moshberg briefly touched on that they did not properly consider that. The motion for leave to amend was based on further discovery that they would get, not let's motion to amend now because we realized we didn't properly plead this phrase, this allegation of cohabitation. It was based on further discovery. And so we have no evidence that the court didn't consider that. But even then, there is, I struggled to find a Fourth Circuit case, but there is one at a Southern District of New York that says a simple request for leave to amend within an opposition to a motion to dismiss is not proper. It's not procedurally proper, that should be made in a separate filing. We argued that in our brief, not necessarily that case, but it is a point to bring up that, hidden within a motion, the opposition to motion to dismiss, shouldn't be a procedurally accepted ability to motion to amend your complaint. And then moving now to what we are saying is the crux of this argument is whether or not there was a proper pleading. As this court has alluded to, it is a 10-word phrase. There is in the complaint in its entirety, as the district court alluded to, reading through it carefully, there is no factual allegation to support this 10-word phrase that's found in the middle of one paragraph. As appellants, as we argued, the appellant didn't argue that within his the request for relief, the cause of action. Nothing specifically states a challenge to the analysis, the USCIS analysis that they allude to here. It is all, I should say it's all, the very little factual allegations that they do argue surround this weight and credibility of evidence, which the district court found is not allowed to be reviewed under this jurisdictional bar.
Counsel,
yes,
do
Your
you
Honor.
have a sense of what that standard ought to be? I'm very sympathetic to the idea that it would have been virtually impossible to expect a district court judge to read this complaint and intuit that this argument was being made. But what standard should I be thinking about when I'm doing that, right? It'd be very hard for a district court to do. It's not typically the way we think about these kinds of questions. Do you have a sense of what the bar is? I mean, in a 12B6, we sometimes say, is it enough to put the defendant on notice? But we're sort of a 12B1, which is maybe more about the court. Do you have any insight for me on that?
Yes, Your Honor. I think that specific the notation that you just made of a 12b6 versus 12b1. We are in a 12b1 standard, and this is putting the court on notice. And I think I've searched trying to find any other case law where a sentence or a phrase in itself does that allude the court to enough to satisfy this Twombly-Iqbal standard of factual allegation. And the only case that I found was out of CD-Cal or SD-Cal, which is Mora versus Chula Vista. I'm not cited in our briefs, and I can give you that citation. But in that case, they held that a single sentence did not hold enough of a factual allegation. So I think the bar here is still building on this Twombly-Iqbal standard. Is there enough to give the court reasonable inference? And when you're based this phrase, this 10-word phrase, based within only one paragraph, without any sort of factual allegation, as Judge Harris alluded to, there's nothing to say they decided this and this piece of evidence is wrong in that decision. They just vague assertions to the overall analysis of the evidence, the overall credibility of the evidence, and not even including the specific statutory analysis that they're saying was wrong. Now, they did argue that within their opposition to motion to dismiss, but it was 3 paragraphs. Once again, it was not a section within their motion to dismiss. It was not a beginning point. Oh, we've missed this point here. Let us touch on it. It was once again woven into their argument that there's a credibility issue and that there is a weight of evidence issue. So
just to clarify, as to the brief and whatever role the brief should play in looking at whether this issue is raised, your view is you could look at it to give context to the complaint. It's relevant, but it also does not do enough to put the court on notice.
Yes, Your Honor. And the Fourth Circuit has affirmed that in, I believe it's Laboratories, Inc. for ASCO in 1993. It's an older case. This is also a District of Maryland case that was affirmed in 2019 that a complaint may not be amended by briefs.
Right.
And specifically in opposition to motion to dismiss, that was a State Farm case out of the District of Maryland, is that you cannot use the opposition to motion to dismiss to further an issue in a brief that you did not allege enough. And so,
wait, I'm sorry. I think you were giving. I think I fed you. I want to make sure I understand. I know that rule, and I think your colleague agrees. If the 10 words weren't in this complaint, it wouldn't matter if he filed a brief that had on the front cover, here's my issue. It's about finding this residence. It would not matter. But I guess my question is, in figuring out like the right context for looking at the complaint, like what is it, what would or would not put the court maybe on fair notice if we think the standard is somewhere in that ballpark? Is it fair also to look at the brief in terms of sort of context evidence for what is in this complaint? Do you know what I'm saying?
Yeah. I think everyone agrees, John, that and as my colleague pointed out, that the briefs themselves are to build up arguments to expand on the facts, expand on the law, expand on the regulations. Right. That's us telling the court we think this X, Y, and Z results in a decision. But I think here you have none of that. Right. The motion to dismiss, and we do agree that this was not the most well-written opposition to a motion to dismiss or a complaint. I think a lot of us have seen good and bad ones throughout our careers, and we can all acknowledge that. But the fact is that doesn't measure into what the court should decide here, whether or not it was a good or poorly written brief. It's whether or not it met the standard. And you can explain X, Y, Z in your briefs all you want, but the fact is they didn't either. Right? They didn't expound on that in their brief to a standard that would even kind of, obviously it didn't register with the district judge in this case, that they were arguing that. The district court didn't even get into an alternative kind of decision on the 12b6. Sometimes we will see that where a court goes, I'm ruling that there's no jurisdiction, but also, in case in case that's not enough, we decide that this wasn't met here on a 12b6. The court clearly read this as being not pled enough to even allude to a question of law that would warrant a 12b6 merit. So I think, yes, we can say that briefs do aid the court in expanding upon what we're trying to argue here. But in this case, that brief did not do that. And so the bar here is, it's hard for me to say what the bar actually is, but I would argue that a single phrase, not even a full, complete, compounded sentence, would not warrant a Twombly-Iqbal meeting the Twombly-Iqbal standard here of a sufficient pleading.
But then why was it necessary for the court to go into the record and the posture without notice and just said, what's that? I want the record. If that was so the case.
Your Honor, that's I'm not sure exactly why. So I guess to preface that, I also was not the attorney of the below case.
Right, yeah, we don't take that in the Fourth Circuit. Whoever shows up is responsible.
Right, yeah. Understand that, Your Honor. Yeah, that's we do understand that. You're on the hook for it. But so oftentimes we will include a little footnote saying, please we'll exhibit the decisions. For whatever reason, they did not do that in their motion to dismiss. They didn't attach a decision. The court, looking at the opinion, I would assume, I say this is just an assumption here, that they're requesting the decision as it was integral to the complaint. That's what the complaint was based on, to get an idea of what the facts actually were in the case, just to kind of give themselves a little bit of an acknowledgement here to what did go on. Yes, they received those decisions on the 28th and issued their opinion on the 12th. So that seems to me, 28th of June, 2023, issued the opinion on July 12th of 2023. So that appears to me that they already had an inkling of exactly what they were going to do when they requested those documents. And then that may have just been a kind of okay, yeah, we are seeing this correctly. We are right here. Here's our decision. But I not having any other communication with the court or any other documentation.
That's the whole point. Wouldn't fairness require him to at least have an opportunity? Because you're looking at things, the court was looking at things where there were factual disputes. First of all, they got it wrong as to what the requirement was. And it was that, well, you have to be cohabitating during the marriage and the other facts like that. And then you switch over, and then a few days, a week or so, then you file you grant a motion to dismiss, and all that changed. So a lot of talk about only 10 words, but then nothing on the other side in terms of what happened in terms of procedures. This is a quirky case, isn't it? The court says, I want the records. I don't know what I did, what I pulled from that, but here I'm changing this now without a chance to amend the pleadings or respond. I mean, this is a very important matter, whether or not this person gets, to stay in the country. Those are big decisions. This is not sort of a passerby sort of claim here. But yet every ball drops against him, but not against anybody else in terms of got the standard wrong, and the district court goes in and look at the record and follow through in terms of, based on the respond to it. Wouldn't fairness allow at least that you may amend the pleadings or some hearing in that respect of it? The court just said, well, I don't have jurisdiction because I've determined now outside of this sort of record, and before me, at least for me, I've determined it is. And they're factual questions. Don't you agree that there's factual dispute? Because he had witnesses that say that where they live and those kind of things like that. How was that resolved?
Your Honor, first to point to the regulation. The USCIS decision to deny his I-360 petition was made on the proper regulation at the time. Okay, the regulation, the argument there that the regulation had changed is post the argument that occurs that the case law
Right.
cited talking about that occurred after the USCIS decision. So USCIS decision, apologies, occurs at what the regulation is at the time.
Right.
So that this argument that there's, he should have had an opportunity to, allude to a change in position. That change in position, if I'm correct, occurred during litigation. And so at any point that counsel would have had an opportunity to update the court a supplemental notice that a change in litigation occurred. That never happened. And your point too, that this is these facts of affidavits of the merits question really of the USCIS decision, that is not a jurisdictional question. You have to plead enough to get to the point where the court would consider those options. The court here decided that you did not sufficiently plead. So I agreed that if the court found that you were sufficiently plead, then yes, we would go into that. It would be a 12b6 question of whether or not it was enough. And if that is decided, then yeah, you get to the certified administrative record. You go through the MSJ treatment of both sides arguing why it was not arbitrary and capricious. But once again, here, they state that it's arbitrary and capricious, but they don't state what. They don't state that the specific analysis of cohabitation was arbitrary and capricious. They barely even state that the weight and credibility of evidence was arbitrary and capricious. And so understanding your point of fairness, but the fairness requires that you have to at least sufficiently plead to get to the point to argue what the facts and the evidence portray as it relates to your admissibility or eligibility for a specific visa petition. And that just did not happen here.
And was it necessary then for the court to go in to request those documents? You're saying basically that wasn't necessary, right? Is that your position?
Well, I think the court could have looked at the complaint on its four corners based on the briefing and said that it's not sufficiently pled. I don't necessarily think the court had to go into that. They requested the documents for some reason. Like I said, I'm not privy to that information. And to me, it reads that they wanted more just get background information on the case because, as we've stated, there was little to no besides the I think there's 5 paragraphs. I think it's like 6 through 11. I think in the complaint that talk about the timeline of events, and that really was only he applied, they denied, he appealed, they dismissed. There was no other factual allegations within the complaint for the court to even kind of understand what was going on. Now the briefs did include some factual information, but the court, I think, took it on their hands to say we at least want to know what this decision is, or at least have a look at it to see what's going on. But I can't say one way or another why the court did that. But I know I have 30 seconds here. Just to
have you ever been involved in a petition for review of an agency decision here that didn't involve the decision? I mean, it seems odd to me that we would even think about a petition for review of an agency decision without the agency's decision.
Yeah, and Your Honor, I see that my time is about to run out. Just to briefly answer your question. Okay. As I alluded to earlier, I personally have never filed a motion to dismiss in district court, and I've been with the DOJ for over almost 5 years now. That did not include at least attaching the decision to the motion to dismiss, and almost every circuit allows that sort of document to be attached because it's integral to the complaint itself. And that's with any APA argument, because you are arguing that the agency final agency action, which here would be the denial, is arbitrary and capricious in some point. And that is almost impossible to look at without attaching the decision itself. So, I think the court was right to look at it. I don't think they needed to look at it because the complaint itself was deficient and did not meet the standard. And so if no further questions, Your Honor, thank you.
All right, thank you. Counsel,
Certainly.
Thank
you, Your Honor. Just to briefly respond to my colleague, we did cite Gay versus Wall in our briefing. It's at page 19 of the opening brief. The the plaintiff below actually did advise the district court of this shift in the USCIS, or this reversal in the USCIS policy. That's at page 62 of the joint appendix. The 3 paragraphs that have been referred to in the opposition to the motion to dismiss, really, pretty much all he does is tell the court, actually USCIS has shifted its position on this, and cites to the 2 of the 3 on-point federal district court cases. So that fact was certainly in front of the court, that USCIS had shifted its position on this. Certainly, I mean, if I agree with Mr. Young on one thing, and we actually agree on several things, I've filed half a dozen of these APA cases in district court, and I would never not attach the decision that I'm challenging to my complaint. So I think at core, our dispute or our squabble with the district court is not that the district court chose to review the actual agency decision that is the subject of the litigation, but rather that the district court did not allow any briefing thereupon, right? And just rendered a decision in a manner that surprised the parties and didn't give them reasonable opportunity to brief on the actual decision itself. At the end of the day, if the district court sort of was left with the impression.
I'm sorry, just so I just really am trying to get my hands around kind of the practical issue, and I may be missing something important here, but did your client not have these decisions? Is that your argument, that no one had seen these decisions?
No, no, Your Honor.
Your client had them. Okay, so your client could have briefed them. What was stopping anyone from briefing the decisions then?
They weren't in the record. They weren't before the court, right? I mean,
But your client's alluding to them. I just practically speaking, I'm trying to figure out the lost opportunity here. I mean, your client and his then lawyer wrote a complaint based on those decisions, and then a brief based on those decisions, and it just doesn't seem like there was any meaningful unfair surprise or anything here. Everyone understood this case was going to be about those decisions.
Yes, Your Honor. I think at the end of the day, the defendant below took a sort of a tactical litigation decision not to attach those decisions.
I'm not sure. Just for what it's worth, in my experience, since we're all talking about our experience, sometimes the government forgets to attach them, and I get very cranky and say, where are my decisions? So it does happen.
Fair enough, but this is certainly not a situation in which they said, for example, see Exhibit A, and then there was no Exhibit A, right? They took a decision, whether tactical or improvident. They took a decision to essentially attack the 4 corners of the complaint. And so the opposition to, on a facial 12b1, which is held to the same standard as a 12b6, right? So they're attacking the allegations in the complaint, and the plaintiff responded there too. Right, responded by doing his level best to explain why in his mind, the complaint was sufficient. And one of the explanations he gives is that it properly raises this issue about cohabitation prior to the marriage versus marital cohabitation, which is a legal mistake by USCIS. It's a wrong interpretation of the statute, and USCIS actually now recognizes it to be a wrong interpretation of the statute.
Okay, and then
so at the end of the day.
And then what was the problem with that? Because that is what the district court decision turned on. So again, I guess maybe in technical terms, what's the prejudice here? Like what is it your client would have said differently had he only known this case was going to be about these decisions?
So no, sorry, I don't mean to leave the impression that somehow the plaintiff thought the case was going to be about something other than the decisions at core. There was a motion presented to the court that said that the complaint wasn't good enough. The plaintiff responded to that and said, actually, I think this complaint is good enough. And then from there on, everyone is sort of left thinking that the court is going to decide whether or not the complaint is good enough. The court then says, I actually want to see the substance of the decisions, and I'm going to look at the substance of the decisions, and I'm also going to see I'm going to see the whole administrative record, right? So essentially, everyone is sitting here thinking, all right, this is sort of turning into summary judgment territory, right? But then at the end of the day, a snap sort of surprise decision came out prior to the administrative record being filed, and there was no opportunity to brief the substance of the decision. So the
Is this what
court-
I'm forgetting? I thought the decision that comes out is about the four corners of the complaint and whether or not the complaint is alleging anything other than an evidentiary weighing dispute. So that's that's the piece of the puzzle I'm missing. If the district court had then issued an opinion saying, forget all that stuff you guys briefed, now I have the opinions and I would like to decide this case on a different ground based on, say, the precise wording of those opinions, then I sort of understand what went wrong here. But given that the district court decision is based on the same issue that was in fact briefed, why does it matter?
I actually, the way I read the district court opinion is actually the latter, Your Honor. But
Okay.
even if it were the former, I think that this is absolutely a case in which one could not say that it would be futile to amend. Right at the end of the day, denying leave to amend was an abuse of discretion because there was shown to be there was shown to be at least a scrap of meat on these bones, and so therefore futility can't be shown, and that's really the only argument that appellees are making against leave to amend. And so it was an abuse of discretion. If one reads the district court decision and takes all of the pages and pages of references to the actual USCIS decision and says that's all really kind of background and is immaterial to the holding and is sort of dicta, as it were. If one reads the district court decision in that manner, then this was clearly a case in which futility cannot be. It would not be futile.
Can I ask a related question here? So we've said in a number of cases like Wilner and a bunch of others that where there's not a sort of independent motion and where there's not a proposed amended complaint, the district court's discretion is at its height, and we don't sort of look for futility or anything else that's sort of sufficient, and sort of help me understand why that's not the story here. I mean, there wasn't a lot of information given that would have suggested to the district court that an amendment here would solve the problem.
Certainly, Your Honor. I think that I'm not aware of a rigid rule that requires that in the context of a 12b6 motion to dismiss or a facial 12b1, which is held to 12b6, I'm not aware of a rigid rule that requires that in opposition to a 12b6 that says, well, I think I did good enough in my complaint, but in the alternative, I should be granted leave to amend. I'm not aware of a rigid rule that says that has to be done by means of a separate pleading with a proposed amended complaint attached thereto. Certainly, this is all committed to the sound discretion of the district court, but this court has held that, the three factors that are taken into account, right, are prejudice to the opposing party, which is not alleged here, bad faith, which is not alleged here, and futility. And so
just to give you the response, it says, where they fail to formally move to amend and fail to provide a proposed amended complaint or indication of the amendments it wishes to make, the district court does not abuse its discretion in denying a leave to amend. So I take that to mean when the first two conditions hold, then it is definitionally not an abuse of discretion. Now, of course, a district court could grant the motion to amend, but in essence, this is another version of, if you don't give the district court some sense of what's happening, we're not going to find the district court abused its discretion for failing to ferret out what you might have wanted to do had you articulated it.
Certainly, Your Honor. And my only response to that would be that I think that on the procedural posture of this case, it's quite distinguishable, right? Precisely because we're in this moment of time where all the parties are in the understanding that the full administrative record is about to be filed, and then the court sort of short circuits that. And so for that reason, I think that case is distinguishable, Your Honor.
Yeah, I think that's clearly what makes it different, doesn't it? Exactly, because they were told this was going to be all on the pleadings. This was going to be on the pleadings, 12b1, and then you get the opinion, you ask for that, the record, and then all of a sudden you get, 12b6 dismissal. So I agree with Judge Richardson. Normally, that's a situation where you would do that, but this is different, and that's what I'm saying. The difference is it looks like it's all falling down on him and nobody else. Uh, if the court, going after looking at those documents, say, this case really is motion to dismiss 12B6. I want to hear your views on that. But instead, you just make the shift, and all they get is an opinion and not a chance to amend. That's the problem with the case. That's the unfairness of it. Not necessarily whether or not he would or would not prevail. That's not the question. The question of justice is procedure. We'd hope that their outcome would be the right one, but we judge it based on the process. And then you switch this thing around and tell everybody, look, I see what counsel is doing when somebody said, you don't even, 12B1. I'm not going to open the door to make it a situation where I might get bounced out if you're going to just do it on the pleadings. You want to stay in that. And then he didn't know until an opinion comes out that no, this is the whole shenanigans, and the case is dismissed, and you don't get a chance to even amend or respond to it, and that just seems like it's as I would say, Gronibus is not a fair fight.
Yeah, I mean, this is a blessedly rare situation, right? I mean, fortunately, cases of this nature do not come before this court with any regularity. It's, if anything, we can say it's sui generis. But we're certainly not arguing that any one of the what we are calling errors by the district court, in and of itself, is enough to require this court to find abuse of discretion. But when you look at the constellation, right? When you look at the procedural posture combined with the denial of the leave to amend, combined with, I think when you look at all of those together, this court can find that just, on these facts, the district court abused its discretion in the manner in which it decided the case.
I'm sorry. I'm so sorry. Can I just ask one clarifying question?
Yeah, go ahead,
Sorry.
Judge Harris.
Of
I
course.
thought you were arguing. You don't have to look at anything else. This complaint raises a legal question. The district court said it didn't, and therefore the district court dismissed under 12B1 for lack of jurisdiction. And that was a mistake. And it really doesn't matter what else happened. That's just a legal error. Now you're saying, no one of these things was a mistake. I have to look at all of them together to get to the district court having made a mistake here?
I apologize, Your Honor. My last comment was with regards to the sort of discretionary issues before the district court. Whether the complaint stated whether jurisdiction is a legal issue, which this court reviews de novo.
Okay.
Yes, no, you're absolutely right to correct me because I was a little unclear about that, Your Honor. Thank you.
Sorry.
I'm referring to the discretionary questions, which are the leave to amend, asking for the documents, issues around timing. Those are all things that are committed to the discretion of the district court. And when you take all of those together, I think that this court can find an abuse of discretion.
Thank you, counsel. Thank you both.
Thank you.
Your virtual greeting we'll have to do. We appreciate your arguments, and thank you much, and be safe.
Thank you. Thank you, Your Honor.
Likewise, Your Honor. Thank you.
All right. Counsel, Mr. Previs, you may proceed.
Thank you, Your Honors. Good morning, and thank you. It's a privilege to argue in front of you today, and it's a shame that I can't be there in person. My name is Tom Previs, and I'm a lawyer at Saul Ewing. I represent the appellants in this case, which were the plaintiffs below. As previously indicated, I've reserved 5 minutes of my time for rebuttal. May it please the court. The appellants are 3 individual families that live adjacent to an area that is subject to a land disposition development agreement, which is in question in this case. Appellants are also the Poppleton Now Community Association, whose members include the individual plaintiffs who are my clients, members whose homes were taken in connection with the land disposition and development agreement, and members who just have a generalized interest in the benefit of the neighborhood. And the purpose of the Poppleton Now organization is to elevate and to advocate for the betterment of this particular neighborhood. Appellants seek judicial review of a state action that they claim violates the Fifth Amendment to the United States Constitution, and more particularly the public use clause of that Fifth Amendment. The district court dismissed the case on standing, effectively holding that federal courts are not available to review this constitutional question as a matter of subject matter jurisdiction. For the reasons I'd like to go over with you today, the federal courts have unquestionable subject matter jurisdiction to address this claim. I'd like to first take a moment to summarize the facts very briefly, the allegations very briefly, before I turn to the question of subject matter jurisdiction, which is at the heart of this matter. The facts. In the summer before the complaint was filed, new information came to light through an investigative journalist. The information particularly noted that the developer, which is one of the defendants in this case, solicited a proposal to redevelop this community in the city, that it was a historically Black and underprivileged community, and that the proposal was not previously contemplated under city land use agreements, but was unsolicited by the developer. A city panel ultimately awarded an RFP to other developers and deemed that this developer was unqualified. At the same time the RFP was pending, the developer provided in-kind gifts to a then city council president, later mayor, which included a spa day and a spread in a national magazine touting her community development prowess. In the same month that that national magazine article ran, the RFP was changed and the project that was solicited to the developer was awarded to the developer. The parties then entered into a land disposition development agreement, which was unique and one of its kind for these matters across the country and directly violates the Constitution. The land disposition development agreement gave away 13.5 acres that would be taken from private underprivileged property owners to this developer and does not first require the delivery of a public use. Whether the text of it says it or the parties are enforcing it that way, that is the current situation. And now we're 20 years later, but that is still the current situation, which is that the developer takes the position that he has a quote unquote development right over all 13.5 acres, and that nothing can be done with those acres until someone pays him off the full market value. He holds the land hostage and demands a king's ransom if anything is to be done with this entire neighborhood.
Is that, I guess, can you at least take a minute for mootness purposes and talk about whether the developments that have happened in the last couple of years, including the, absolving of this particular agreement and the land being transferred to a party that I believe is not before us, how that affects our jurisdiction under a sort of mootness doctrine? It seems like we're far afield from where you just said that's how everything remains. That doesn't seem to be true.
Let me address that because there may be some confusion. There's 13.5 acres subject to this land disposition development agreement. 2 limited parcels were taken out of that, and I think that may be what you're referring to. 2 limited parcels were taken out of the land disposition and development agreement, and the city purchased those at market value from the developer, with this developer having not performed anything of value, and then the city then developed them themselves. Those two parcels are just a tiny fraction of the remainder of the 13.5 acres, which sits fallow and empty with nothing on it, and that will never be developed so long as this is in place. The fundamental problem is there are 13.5 acres that were taken, and the city has paid $1 million for 2 tiny little parcels, close to $1 million, for just to release 2 tiny little parcels from the purely private interest of this developer. The remaining, I don't know what exactly number it is, let's call it 13 acres, is subject to the same situation, and it's going to sit there fallow and under the same unconstitutional condition until the city pays him the remainder of the money, presumably more than $10 million, just as a threshold and starting point for the delivery of a use. And so I think the answer to your question is it's potentially moot as to the 2 things that were taken out, but we still have the situation that would be redressed significantly by a court order indicating that the LDDA is unconstitutional, that the remainder of, let's call it 13.2 acres of this neighborhood cannot be subject to this purely private inurement, and a public process needs to take place to provide for a public use of this, which is entitled by the Constitution of the United States.
I'm sorry, are you asking for damages also?
We have asked for damages in the form of loss of property value and loss of use and enjoyment primarily. It's part of our nuisance claim. It's also part of the 42 U.S.C. 1983 claim. I will say, however, that the primary relief that we seek is purely declaratory and injunctive in nature, in that we simply seek that the federal courts, which it has every right to do, review not only the initial arrangement to give the land to this developer, which we say directly violates Kelo versus City of New London and the public use clause of the Constitution, but also the language of the LDDA agreement, which violates the Constitution. It's one of its kind by giving this developer, all of this land without the requirement of a public use. And that doing so would by just removing that substantial obstacle, other actions can then take place that would be potentially for the benefit of the community. As a practical matter, did I answer your question, Judge Harris? I don't want to waste your time.
Yes.
As a practical matter, I think some of the question that you've just asked, and I think what our framers had in mind is, the framers didn't say this is a quote unquote takings clause, although we refer to it that colloquially. They forbade government from taking from a private person A and giving it to B. Now, in Kelo,
can you tell me why? I understand the challenge that could be made there if you were the landowner, right? That's the Kelo cases where they were the landowner. You're obviously not the landowner.
Right.
Can you point me to any instance in which a court has said that a non-landowner can challenge a taking? I mean, this sort of feels a little bit like third-party beneficiary trying to challenge a government contract, right?
I understand.
We're pretty protective of that. Bad government is not unconstitutional.
I understand your question, but I think, I'm not aware of such a case, but I also think that there are cases that indicate that this would be permissible. First, the question of harm is, are they harmed by the lack of the public use? And as we pled, and as I indicated to Judge Harris just a moment, they're absolutely damaged. The loss of property value, loss of use and enjoyment,
we often say sort of incidental, third-party beneficiaries that have incidental effects. Like, it's not that the effect doesn't happen, but it's not a basis on which you can bring suit.
Your Honor, I think that in a lot of cases may be the case. I don't think that's the case here, because they are direct to say that the neighborhood is not directly impacted by living adjacent to this, and as a result of this unconstitutional arrangement is absolutely they are, and they pled it that way. Let me make 2 points, because I don't want to lose the thread here. That one is standing. The question here is standing. And the question is whether the court has subject matter jurisdiction pursuant to standing. I want to your exact point, I want to bring to your attention the case of Duke Power versus Caroline Environmental Study Group, which I think is the most applicable here. First, in Duke Power, the Congress passed a law reducing safety regulations for nuclear power plants. The plaintiffs in Duke Power lived near a nuclear power plant. The plaintiffs in Duke Power argued, among other things, that the safety regulation change about nuclear power plants affected their property value and the loss of use and enjoyment of their property. And they further argued that as a result of living near a nuclear power plant with less safety regulations, they were harmed. The Supreme Court held, that they had stated a cause of action because they had made a constitutional, they had raised a constitutional question under the Fifth Amendment that a state law, here it's a state contract, but it's the same issue, impinged on their property rights and on their rights, and the court reviewed the case. The court further held that they had standing in that instance because they were nearby, based on the basic standing analysis that they were adjacent property owners and that they were nearby.
Counsel, so you started by saying like, this is a standing question, subject matter jurisdiction, and I completely agree that is a threshold question. But whether we think about it as, and I know we have to sort this out, but whether we think about this as a standing problem or sort of a failure to allege an element of a takings clause violation, I sort of want to go back to Judge Richardson's question. I can't find any case one way or another that allows someone to bring a colloquially called takings clause claim, but really a public use claim, based on the taking of someone else's property. And I take your point that there are cases that suggest one might well have standing to bring such a claim, but I can't find anything saying that is a sort of cognizable injury for purposes of a takings clause cause of action, that you can recover for that under the takings clause if your property wasn't taken. But have you found something like that floating out there?
Yeah, so, well, first of all, that was the point I was attempting to make with Duke Power.
Okay, you think Duke Power, but
yes,
it's not a
Duke Power-
takings case, right?
It is actually a takings case. In Duke Power,
They said you could bring it, okay.
they were
They
arguing
said there's,
they were arguing that their loss of use and enjoyment and that their property values were materially affected by the safety regulation change of Congress, and that was unconstitutional. The court didn't rule, and I don't know exactly what happened ultimately, but the court did not rule that they won that case. It's some ultimate trial or something like that. I don't know. I actually, and I apologize, I didn't look at how it came out sort of down the road. But the court did rule for the purpose of 12b1 and 12b6 that they had stated a claim that was sufficient to be addressed. And I want to draw a particular language to Bell v. Hood, which is a 1946 case that addresses this exact issue. Jurisdiction, therefore, is not defeated, as respondents seem to, I'm quoting from the case, which also was quoted in, Duke Power. Jurisdiction is not defeated, as respondents seem to contend, by the possibility that averments might fail to state a cause of action on which petitions could actually recover. For it is well settled that the failure to state a proper cause of action for a judgment on the merits is not for dismissal for want of jurisdiction. Whether the complaint states a cause of action on which relief could be granted is a question of law, and just as issues of fact, it must be decided after and not before the court has assumed jurisdiction over the controversy. If the court does later exercise its jurisdiction to determine that the allegations in the complaint do not state a ground for relief, then dismissal of the case would be on the merits, not for want of jurisdiction. And then it just says that the previously carved out exceptions are when the case is only pled for, say, to create a federal question where there really isn't one. But I don't think that applies here because we're clearly alleging a Fifth Amendment issue. In light of this authority, the Supreme Court not only upheld the standing to bring this case, but also said that it had original authority under Section 1331A and Article 3 of the Constitution to review the case. In light of prior decisions, for example, Bivens and Higgins and Levine, as well as general admonitions that where federally protective rights have been invaded, courts will be alert to adjust their remedies so as to grant the necessary relief. We therefore conclude that appellee's allegations are sufficient to sustain jurisdiction under 1331, which is actually going to a question that's not raised before you today, which is whether we've stated a claim for relief could be granted. I want to be very clear. I believe a lot of conflation has occurred between what constitutes standing and what constitutes failure to state a claim for which relief can be granted. And I think it's very important that we keep those lanes clear. And if you get to the question of failure to state a claim, this authority provides that the court has original jurisdiction to review this exact case.
We're already here now, but Mr. Brief, we're already here now because I don't think what you said is inconsistent with the question Judge Harris asked you. You could have standing to bring it, but you may not meet the elements for a takings claim, and we can rule on different alternative grounds. That they're not inconsistent. Yeah, you may have standing, but that doesn't mean that that doesn't get you where you want to be. The question is this a takings claim? And that's the question any cases that where you actually had a
Oh,
cognizable taking claim where you weren't the owner?
I think maybe
You got standing in some cases, but what are they that you actually prevailed and you're not the owner?
may I briefly respond?
Yeah, sure. Go ahead.
I think the question isn't whether it's a quote unquote takings claim. I think the question is whether under, in particular, the jurisdictional grant is 42 USC 1983, have you articulated that a constitutional violation has caused you injury? And the answer to that is yes. Has it caused you injury as a taking of our property? No, but has a constitutional provision been violated? Yes, the public use clause. Has it harmed the plaintiffs? Yes, it's harmed them for all the reasons I've already mentioned. And so you can't look at it so narrowly as, is it a quote unquote taking claim? I'll also add that we have made a taking claim in the exact same way that the Duke Power people made the taking claim, which is that this government action on adjacent property harms the use and enjoyment of our property and the property values. And I could demonstrate that very clearly in a trial. Just as a quick final corollary to that, there's a case 120 West Fayette Street, which is a Maryland case, which directly holds the same, which is that a LDDA regarding a property across the street can be challenged and a declaratory judgment is available simply because the fact that the city issued the LDDA might harm the competitive interest of the property owner across the street. And that case is directly on point. Granted, it's a state case. So with that, with Duke Power and 120 West Fayette Street, I think we get there, and I definitely think that standing has been found in this case as well. Standing is clear in this case as well. Thank you.
All right. Thank you, Mr. Phillips.
You're on mute.
Thank you, Your Honor. And thank you, Chief Judge Gregory. Good afternoon, Your Honors. May it please the court, Anthony Phillips arguing on behalf of all appellees. The district court correctly dismissed the complaint in its entirety here for three independent reasons. First, plaintiffs failed to allege the injury in fact required to establish standing for a takings claim. Second, they failed to allege the type of interference with the use and enjoyment of their property required to state a private nuisance. And third, their request for declaratory relief rises and falls with those substantive claims, all of which were properly dismissed by the court below. Plaintiffs have abandoned their other claims on appeal, and there's no basis on this record to disturb any of the district court's reasoning below. This court should affirm. Here, despite the distinct roles of courts and elected officials, plaintiffs are asserting generalized grievances and objections to a lawful local government decision, specifically the city's decision to award the LDDA to developer defendants and the execution between the defendants of that contractual agreement. Those kinds of policy disagreements must be pursued through the political process. Article 3 doesn't allow them to be repackaged as a federal lawsuit.
Yes, can you, I struggle with that a little bit, and I'm just sort of trying to put myself in the plaintiff's shoes, and I'm picturing like my local government rezones, and now there's a factory next door to my house. It runs day and night, and there's a lot of traffic on my street. I can't sleep. There's the bad smells and everything. I'm not really seeing that if I sued, I'd be suing as like just a citizen who objected to a change in zoning rules. I think I'd be suing as someone who was quite in a very particular and concrete way injured by what the government had done. Like, I don't know that I could recover on a takings claim, but if I had some other cause of action, you're saying no, I would not be injured in a particular way by that action?
Well, Judge Harris, your hypothetical is an interesting one. It's not exactly the facts of this case.
It's pretty close to the facts as alleged, right?
Well,
You started by saying they're challenging a lawful government action. Like, we can't do that. At standing, we assume the merits of their legal position. So what they are challenging is the unlawful creation of a government blight right next door to their house.
I'm not certain that I agree that that's their allegation. I mean, the blighted conditions on the record, have existed since 1975. But the hypothetical that you posed, Judge Harris, includes what the court here, what the Fourth Circuit has called a tangible invasion of the individual property. That would be an invasion of odors, of noise.
That's whether I can prove my trespass case, whether I can whether I've pled the elements of private nuisance or trespass kind of a situation.
That's right.
But I'm just saying, I think I can get into court to make the argument. I mean, I just don't see why an argument that you live next door, your property abuts this property, and major changes on that property have dropped your property values and substantially interfered with your use of your property, how that is a generalized grievance about illegal government conduct. It seems quite particularized.
I think I understand your question and maybe where we're missing each other. The court below ruled that these plaintiffs didn't have standing to challenge the takings. That is a separate issue and sort of, I think, where I'm standing on this issue of standing as well. With respect to the takings claim, the district court found that they did have standing.
Oh, no, you mean the nuisance claim.
Excuse me. Thank you, Your Honor. The private nuisance claim.
But how can the answer be different? Either way, what you need, like the requirements for an Article 3 injury don't vary with your cause of action. Like you may win or lose on different causes of actions, but either you have been concretely injured or you haven't. I found that very puzzling.
Well, the injury, in fact, that a party alleges has to relate to their claim for relief. And here,
it has to be caused by the action they're challenging.
Yeah, I agree with that, Your Honor. And I guess the point that I'm making is that if the action that's being challenged is an improper taking, they have to have an injury, in fact, that relates to that improper taking. And here, none of these property owners allege any legally protected property interest. Excuse me, none of these plaintiffs allege any legally protected property interest that could be redressed by the court in ruling on a takings claim.
That's just saying they lose on their I am having a lot of trouble drawing the line here between Article 3 injury and a merits argument, I guess is what I am saying.
Yeah.
That sounds like an argument for why, even though they've been injured, they're probably going to bracket, but there is an argument that they may well have Article 3 standing, but they still lose because nobody thinks you can recover on a takings clause claim if your property wasn't taken. But whether that is an element of the cause of action or a requirement of standing is very confusing to me.
And I guess maybe I don't have a great answer for you, Your Honor, but ultimately to demonstrate an injury in fact in the takings context, there has to be a loss of a legally protected property interest. And none of these plaintiffs have shown that. And with respect to the private nuisance claim, while they have standing to bring it, the law clearly defines what constitutes an intrusion that would make out a private nuisance. And plaintiff's private nuisance claim fails for lack of any cognizable injury under that concept. The district court here didn't weigh the degree of interference alleged. It correctly concluded that the types of conditions that plaintiffs identified, empty houses, tall grass, rats, and trash and vacant lots, parking conditions on public streets, these are not the kinds of interferences with the use and enjoyment of one's own property the law recognizes as a private nuisance.
Can I just ask you one separate, and then I will leave you alone, but just one separate question about the private nuisance claim. I had a concern that really doesn't go to the merits of the district court's analysis, but the district court dismissed, this is here on federal question jurisdiction, I think, and the district court dismissed all the federal claims. And at that point, the default rule is actually that you would not exercise pendant jurisdiction to resolve the remaining state claim, although a court has discretion to do that. But the court's supposed to make a discretionary determination about whether, even though there is no longer a federal claim, in this case, I should go ahead and reach a state law question, or whether that would be needlessly deciding a state law question and you should just dismiss and send it back to the state court. And I didn't see the court make that determination here. And I'm wondering whether, if we were to agree with you hypothetically that one way or another there's no federal claim in this case, we would have to send this back to the district court to consider whether or not it wants to exercise jurisdiction over the state law claim. Sorry, that was a long question.
No, I think I understand your question, Your Honor, and I don't know that it's necessary to send this back to the district court to make that decision. This review, of course, is de novo, and as long as the court were to conclude that if the court were to conclude that a nuisance claim has been plausibly pleaded, once that takings claim is dismissed, there really is no basis for federal jurisdiction, and it wouldn't need to send this back to the district court to reach that conclusion. This court can reach that conclusion on its own, and in that circumstance, particularly here where we are pre-discovery, exercising supplemental jurisdiction would not be appropriate.
Thank you.
And so ultimately, I would go back to.
And can you talk about your colleague puts a lot of weight on this Duke Power decision and the suggestion that Fifth Amendment claim, which includes a taking piece, but seems to be more about a due process claim, but there's at least a Fifth Amendment claim in the case, whether it's discussed by the court. Can you talk about why you think that doesn't apply here, or why you think it's distinguishable?
Yeah, my understanding or my read of the Duke Power case, Your Honor, is that the court rejected the takings challenge because the plaintiff had no vested property interest that had been taken, reinforcing our position that the takings clause protects only concrete property interests, not, abstract or speculative expectations. In Duke Power, the court found the plaintiff had standing to challenge a statute that removed a future tort claim, which is different from a property interest. In the Duke Power case, the statute limited the liability arising from, the potentially dangerous conditions of the power plant. And that is what the Duke Power court found plaintiffs had standing to challenge. It wasn't they didn't find that they had standing to challenge the taking of a property there. Instead, it was the taking of this a future tort claim. I hope that's responsive.
Yep.
And so, returning to this case, I think it's also important to recognize that the private nuisance claim that has been raised here does not sufficiently state a claim, and that's what this court found. So the judge here, and the district court judge here, didn't find that plaintiffs could not raise their, or lacked standing to raise their nuisance claim. Instead, what the district court found is that the types of conditions plaintiffs had identified were not the category of harm that could amount to a private nuisance. A case on which plaintiffs rely, National Fair Housing Alliance, points out that there are two requirements to make out a private nuisance claim in Maryland. One is that the injuries of a character to diminish materially the value of the property for use as a dwelling, and two, the actions cause serious interference with the ordinary comfort and enjoyment of the plaintiff's property. The district court here didn't reach the first question, but resolved this matter, or resolved the 12b6 question on that second element, serious interference with the ordinary comfort and enjoyment of the plaintiff's property. Nowhere in the complaint do plaintiffs allege that they've lost any use or enjoyment of their own property. The conditions they complain about, or that they allege, are all external to their property. And none of those external conditions, none of those external concerns rise to the level of what this court has called a tangible invasion. Again, a noise, an odor, a light. Those are the types of issues that are constant and ever present on an individual's property that this court has found can amount to a private nuisance. Absolutely.
Can I jump back? I think I know it's out of order, but I'm just trying to think about this question of whether this is a standing problem, and I'm back obviously all the way at the beginning. I'm talking about the quote unquote takings claim, and I'm trying to put it in sort of like the TransUnion boxes, and we think about the constitutional law injuries that the court describes as intangible injuries, and it sort of describes those as being like a permissible type of injury, and it seems like that probably, like, you would probably win if that was the bucket that we found ourselves in. I guess what I'm trying to figure out is why, for TransUnion purposes, this isn't like just a tangible pocketbook injury, right? My house is worth less today than it was or would have been absent this non-public use taking. And so I've got a tangible pocketbook injury. And so this whole question about sort of, intangible harms identified in constitutional principles, we don't get to, because we've got a tangible, at least by allegation, a tangible pocketbook injury. Like my property is now worth less.
Yeah. And I think I understand.
And so then but that would then suggest you might lose because the cause of action doesn't exist, but that under at least the TransUnion, buckets that I'm thinking of, you've actually got standing.
Yeah, I think I understand your question, Judge Richardson.
It'd be hard if you did, so I'll give you a lot of credit if you're close.
I'm doing my best. If I understand your question correctly, I think what I hear you saying is that if my property is worth less today, haven't I suffered a taking that I can at least raise in court?
No. It is that if my property is worth less today, I've suffered an injury. Right. So a monetary pocketbook, tangible injury. Right. This is Judge Harris's example. Where the factory gets located on our street, except it's not a factory that smells bad or makes noise. It's super quiet, right? But it just happens to have the effect that it really lowers the property value.
Sure.
And I don't know why that is, but we've got lots of experts that say it lowers the property value, right? So it's not, she's still able to sleep well and all those things, but the property value has just gone down. And so I don't care whether it's a taking or not, right? My point is the government took action. My property value went down. And for standing purposes, I've got a tangible pocketbook injury. And so we're like done under TransUnion.
Right.
Tell me what am I missing there?
Yeah, and I think probably what's missing here is that those facts are pretty extreme and quite different from the facts here. But even if we start with that injury, you also have to follow that with causation and redressability here.
Yeah. Okay, fine. But so stay with my hypothetical. I understand you think the facts here are different, and we can talk about that. But let me go back to destroying Judge Harris's financial well-being, if I can. So the building is built on Judge Harris's street. And so we accept the property value's gone down. That's a tangible pocketbook injury. But we can say pretty clearly, like, well, that's not too hard to think about traceability, right? Because we know the property value went down because of this like monstrosity that was built across the street. And then we say, well, is it redressable? Well, yeah. I mean, one way is you can just pay them some money, right? The other way is you can tear the house down, right? Or the structure that was built, right? Maybe we're not going to do those things, but like for standing purposes, why isn't that enough?
Yeah, I guess my reaction to that one is that no one has a constitutional right in the value of their home, right? So this hypothetical assumes that the loss of home value is an injury in fact, and that's not what the law says.
No. I think the law says like a tangible loss of value is a tangible injury. Right? The loss of money is a tangible injury. TransUnion's really hard when we talk about intangible harms. And those are super difficult, right? Like I get it. But it's not hard when they're talking about tangible injuries, right? Like you've lost value. And the fact that like it's, nobody went into Judge Harris's house and took the $100 and burned it, but instead caused her that same loss in value. Like that's a tangible injury just the same.
Yeah, and Judge Richardson, I apologize. I guess I don't have a good answer to your question. I think ultimately on the facts here, the case is simpler. Ultimately, these plaintiffs are alleging an improper taking for lack of public use. But of course, the LDDA itself is in the record. The facts of this case are squarely on four corners with Berman v. Parker, which unanimously decided that the taking of private property to repair or cure a blighted neighborhood is a permissible public use. I mean, those are the facts that we have here.
Right. So I guess that they're then, except for a minute, my theory here that you have a standing is okay. You then have two different ways that you might prevail. One is to say you got standing, but you got no cause of action, right? Because a 1983 suit for a taking for similar principles to third-party standing to challenge a third-party beneficiary to bring a claim on a contract simply doesn't exist. All right, and so that's sort of like a threshold question. And then your final point, which I take is what you were getting to, probably well beyond what we can do, is that this is actually a public use, and they really lose on the merits at some point down the road. Those are three different grounds that we could talk about. Do you see those as being the three buckets?
Yeah, I think that's right.
And so on the second bucket, which is, okay, maybe they're standing, but there's simply no cause of action that exists under the takings clause when you're not the property that's been taken. Do you have an argument there that we should think about?
Well, I guess I would say that if we assume that standing is proper under these circumstances, I think that is certainly right. I think certainly if the cause of action is an improper taking under the Fifth Amendment, that would require the taking of private property without just compensation. And so if these plaintiffs were found to have standing to challenge the takings of of the relevant properties here, none of them owned any of these properties. And so ultimately they're not stating a proper takings claim if they're suggesting that the taking of other people's property gives them the right to sue. I hope that's responsive to your question.
It is. Thank you.
Yeah, and ultimately, Your Honor, or Your Honors, this case, I think is simpler than all this. I think this case presents no concrete or cognizable injury to these plaintiffs. I don't think there's a viable federal cause of action here, and there's no basis for this court to intervene. Ultimately, the LDDA was negotiated and is being executed at arm's length between the city defendants and the developer defendants here. What these plaintiffs are complaining about are ultimately political decisions and the actions of their local government. And the courts are not the proper party to resolve those disputes. I mean, ultimately, here plaintiffs are 6 individuals and the community organization that they control. And they assert that what's happening with respect to this redevelopment is bad for the community. But the elected representatives from the city of Baltimore represent thousands of people and hundreds of other people who lived in this neighborhood. And there are facts in the record that show when this RFP was put out and this LDDA was considered, there were 4 large community meetings held, and this was a generally favored redevelopment. So with that, Your Honors, unless there are further questions, I'll yield my time. Yield the floor.
Thank you so much, both counsel. Appreciate you. We thank you so much for being here. We can't come down and salute you, but know that it's much appreciated for your advocacy. Be safe in this weather.
Your Honor, I think the appellant has a little bit of time.
Oh, I'm sorry. We didn't eat his time away, did we?
I mean,
my apologies. Go ahead, Mr. Previous.
He'll promise to end quick, but I'm at least interested in what he's got to say.
Well,
I am too.
At the risk of
apologies, Mr. Previous. My apologies.
At the risk of getting between Judge Gregory and his lunch, I will endeavor to.
Well, I don't eat lunch, so you're okay.
I think to be perfectly blunt, I think the judges of the court understand the issues here and understand that this is not a standing issue. This is a whether the plaintiffs can prove their case at trial issue, and that not only has Duke Power and Bellevue Hood, and also this court in DeCoco v. Garland also reiterated those same principles, that it's not a lack of subject matter jurisdiction to allege that there wasn't an injury to the plaintiffs. And so I think we've circled the issue, and I think that a remand to the district court is more than appropriate.
Can you tell me why? So assume, maybe hypothetically, maybe not, that I think you've passed the standing bar, but it seems just sort of as a matter of law, you haven't pled a takings claim. You might have a private nuisance claim, but bracket that for a minute and just talk about the sort of basis for federal jurisdiction, like why, as a matter of law, a non-property owner can challenge a government taking of somebody else's property. That's not one that I'm familiar with.
I mean, there's certainly times where people present arguments that haven't been exactly tried before on all fours. What I will say is that the plain text of the United States Constitution provides that I'm going to paraphrase, but that the government will not take private property except for public use, period. The public use clause is an important clause. To call this a takings claim is to assume that the forefathers knew of a concept called a quote unquote takings claim, and that their concern about a taking for the public use is limited to the four corners of the taking.
But wouldn't this like go all over the place in other areas, right? Where I could say, listen, I'm not the one that wants to speak, right? But the fact that this guy is like pamphleteering on my street has lowered my property value. And so I want to challenge the grant of his First Amendment rights, or police are doing these stops in my neighborhood and that has reduced my property value. So I can challenge the reasonableness of these stops. I mean, this sort of move to say that when we're talking about a constitutional violation, someone who's not actually been subject to that violation or regulation can bring a challenge would seem to be like a really remarkable one.
I think this is very, very unique to the words of the Fourth Amendment and the clause that is in question here, which is that the taking must be for a public use. And I want to just take that for a second and let's just think about for a second what we're talking about here. We're talking about the potential for a government, theoretically, to condemn, I'm just making up a hypothetical, you could condemn half the city, Vladimir, maybe I shouldn't say it, a different government in a different time could take half a city and hand half that city to a private person that is a crony of his, that is closely related to that person. And then that person would come outside the strictures of government and would be a person that could run that entire side of the city.
Counsel, it just seems like if that happened, you would expect one of the people whose property was taken to bring a takings claim. And the fact that they haven't here, I mean, Judge Richardson was talking about third-party beneficiary cases, and I'm also thinking about third-party standing cases, where even if you have Article 3 standing, we don't generally let one party sue, even if they have standing, to sort of vindicate a constitutional command that's obviously aimed at someone else. And just to be fair, like the constitutional provision, it's not a standalone thing that says property should only be taken for public use. It's combined with, and then you have to pay the property owner. Like this clearly this is primarily a protection for property owners, and it guarantees them both that their property won't be taken at all if it's not for public use, and then if it is, they'll get paid. And I do have sort of, whether you frame it as there's not a cause of action or third-party standing, prudential concerns, it just seems like the wrong people are suing here.
I don't agree with you that the principle only relates to the taking from particular.
I'm not saying only, but it's what it's targeted at. It's the primary aim. That's the kind of language we use in the prudential third-party standing cases.
I regard Duke Power as instructive here. If they can sue for the exact same type of situation, which is a nearby regulation that impacts their property value, then these people also can do that. I will also say that were this case to be remanded, as I believe it would be appropriate, on standing ground, because standing certainly applies, there are certain other avenues of opportunity that the plaintiffs can take here through amendment or otherwise to strengthen this claim.
Mr. Previous, to make up for almost shorthanding you, you have any final words to go? I'll give you a minute to close since you had some questions on your rebuttal. You have anything else you'd like to further?
Did you say Mr. Phillips or Mr. Previous? I'm sorry.
You.
I said Mr. Previous, you.
Oh, the only thing is I did not address the nuisance claim at all, but I would like to say that with respect to that, this concept of physical invasion is significantly greater than what is required under Maryland law, and that the plaintiffs have adequately pled that their home values have been substantially impacted, and that that the loss of use and enjoyment is also lost, and that's sufficient. Thank you.
Thank you, Mr. Previous. And same thing I said before. We thank you for being here and appreciate your advocacy and be safe. Take care.
Thank you.
Thanks.
Have a great day.
Okay.
Take care.
Yeah.
Bye.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.